Did you get her a copy of it?
Yes.
Okay. So what do you got to say? Why? There's no reason for the kids to be on your Medicaid if he's got insurance.
I got Medicaid because he didn't have insurance. I've been on Medicaid for about 6 months. He just got insurance. He gave me a card about a week ago.
All right, get the kids off. Get the kids off Medicaid. Tell the Medicaid worker that he's got insurance.
Okay, so what about the child support?
What about it?
I thought this was what this was about.
His request was to get the kids off child support or off of Medicaid. He's providing it. Apparently, the child support order, which is brand new, June 11, 2024, has him zeroed out and he is responsible for insurance. He's provided insurance. Just get the kids off Medicaid and nothing else changes. He didn't file to change child support.
No, that is.
You understand? Well, I don't know what your question is, ma'am.
Oh, sorry. I thought you were talking to him.
No.
Well, because he starts jobs and then quits them, and I'm just worried, like, if he quits his job,
if he quits it, it's something different. But I
I
can't figure out something down the road. I don't know if he will or doesn't. When you got insurance, the state of Michigan should not be paying for medical. When he has insurance, you have the card. You are to go tell the Medicaid people that you now have insurance.
Okay.
Right. All right. Good luck. She's just got to go inform them and get them off Medicaid. All right.
Well, I was also because they're trying to go after me for child support, and we have an agreement in our divorce.
There's nothing here that anybody's done anything. The state of Michigan will, as long as she's on Medicaid. I just told her, get off Medicaid. If anybody from the prosecutor's office or state is trying to talk to them, you got to get that information to them. All right.
Okay.
It's your responsibility to get him off Medicaid. You have insurance.
Yes.
Ma'am?
Yes.
All right. Thank you. We're adjourned.
Now, can I say one quick thing before we finish this?
Well, what is it?
They're trying to go after me for child support now. We have an agreement in our divorce.
I understand. It's probably the state of Michigan. If she's on Medicaid, they will come after you for child support. Doesn't matter what the two of you agree, because I'm not going to let the state of Michigan pay for insurance that is that somebody can be paying for. However, you have insurance. She's to tell them they should drop that suit.
Well, they're trying to go after because she's getting cash assistance too.
No, I don't get cash assistance.
She says no. She says no. She doesn't get cash assistance. I don't know what the state is doing. I just told her to get off Medicaid because she has insurance.
Okay.
All right. Thank you. We'll talk about it. I'm not really sure what. The mother is to. Yeah. All right. All right. Thank you, sir.
Thank you.
Yeah. It's this wait time. Always really helpful. And they wonder why it takes so long to do them.
Is this working?
Yes, it's working. We're waiting for Mr. Bauma, who is logged in, but he's stuck somewhere between there and in. We're waiting for him to pop in. Yeah, why don't you mute for a minute so that you don't just have to sit there. I'm going to take another case, but don't go away in case. Okay, just mute yourself and I'll do a different case.
Okay.
Mr. Cooper, are you there?
Yeah, I'm here.
All right, and
I had my daughter for 9 hours on.
hold on.
Saturday?
I haven't even hold on.
Okay.
Miss Helen, can you hear me?
Yes.
All right. Cooper v. Cooper, both parties are present via Zoom. This is the defendant's father. Motion for custody. There's a 13-year-old child. Dad says on July 6th, child showed up with a rash and bites and stuff like this. And he wants to change custody. Correct, sir?
Yes.
Ma'am, any response?
I sent in a response yesterday stating that
That's late.
that's when I told my grandma was in the hospital.
Well, I'm just telling you, it's late. I didn't get it. So tell me what it is.
I have sent her to the doctor 4 different times over this. And she has been now the doctor sent her to a skin specialist because they can't figure out why the rash is not there. And on the 4th of July, we were at a 4th of July party. And of course, we were up camping. And of course, there's mosquitoes everywhere. And of course, I sprayed her down with off bug spray. And the mosquitoes are horrible.
Okay, well, those look like a lot more than mosquito bites. Hold on. And there is this.
Also, there is a rash on her. We've been dealing with a rash for months. And Kyle tried to have a meeting. I tried to have a meeting with Kyle, and Kyle canceled on me on the very last minute, or he would know what's going on with his daughter. And also, why can't he call the doctor? He has insurance on her. Why can't he know I take her to the doctor?
All right, sir,
And I'm worried about her because she had bruises on her, and I don't know
The
what.
bruises are from a water slide from the 4th of July. I send in pictures.
all right. Sir, in order to have a change of custody hearing, you have to show proper cause or change of circumstance, from.
And
the
her
last-
and the reason why she has anxiety attacks is because she told me last weekend, that Saturday, that she has anxiety attacks at her mom.
I'm
Not
telling
true.
you, you have not
Well,
met
that's
the
what's happening.
burden of, you've not met the burden of proof for proper cause or change of circumstance since the last custody order. I don't see any CPS,
I
anything.
called CPS.
And
Well,
CPS closed it right away.
would the both of you just stop? All right, I have no CPS. You can call CPS all you want. You can call the police all you want, whatever. If there's nothing that they're saying that there's anything wrong, it provides no information to me. I have nothing to indicate that there is anything that would warrant a change of custody. In other words, a proper cause or change of circumstance to even have a hearing on it. There's nothing pled this way. She has a bruise. Yes, I don't know why you were taking a picture of her in the store about a bruise, but on her hip, but quite frankly, and she does have bites on her. Mom has said that the doctor has been trying to treat her for that. Why don't you contact the doctor, sir, and find out
I
what's going
tried.
on?
They wouldn't want me. They wouldn't want me to get information.
Yes, they can.
They didn't. They told me I can't.
Make
'Cause I
sure,
talked to
ma'am,
him.
make sure, ma'am, that he has access to the doctor.
He already does. I made sure that.
I'm
Maybe I
telling
should
you,
know.
I'm telling you right here, make sure he does. Other than that, the motion is denied. Thank you very much.
Thank you.
I only hope everybody continues to interrupt everything I say. All right, Mr. Bauma, are you there now?
Yes, sir.
V. Bauma. A lot of, this relates, there are two kids. One who's almost 17, Mackenzie, and Sophia, who I think is 11. This is mom's custody motion. She did obtain a, ex parte order from Judge Hillary regarding extended parenting time to the mother that came on 6/25. It also required her to file a motion on that. Ma'am, I'm just gonna tell you, I don't know why you waited like 3 weeks or more to file the motion, but we're here anyhow. Dad says he doesn't know why the ex parte order. It's clear that mom alleged to the court, and the court bought it, Judge Hillary, that there's a lot of drinking, smoking pot while he has the kids, leaves the kids home alone. Says, you know, that the one child molested while at dad's residence, although I'm not gonna count that as something that he did, and whatnot. Ma'am, you also say you're moving back August 1st.
Yes.
So that so Mackenzie will be attending Thornapple Kellogg?
Yep.
All right, I mean, I am very familiar with this case. Mr. Bauma, I'll give you a moment to answer, but quite frankly, it wasn't the intent to really change custody of Mackenzie. It was to see to it that she was enrolled at Thornapple Kellogg, and quite frankly, mom had moved an hour and a half away and couldn't get her there. I believe she still attends. Is she still in softball?
Yep.
Yep. Travel ball right now.
Yep, all right. And we're making sure, I don't care who does it, but we're making sure she gets to her travel and all that kind of stuff.
Yes, mom's been doing it all.
All right, sir, what do you have to say?
Well, mom's been doing it all because she hadn't allowed me to take my kids at all for the past month and a half. But I missed out on pretty much the whole summer with my girls, which is, I'm not going to get that time back. The 3 or 4 jobs, I started a new job on June 10th at FCC Construction. It's better hours, better pay, so I'm not working 4 jobs anymore. I work one second part-time job, and that's 1 day a week on Friday evenings, every other week when I did have my girls. So I'm able to be home. I work 5 a.m. to 3:30 p.m. and I work 2 blocks from my apartment. So there's no more the restaurant work that I was doing where I was working 4 or 5 o'clock till 10 p.m. 3 days a week. That's what I believe Ashley was referring to as I'm never home and going to the bar and partying. That's untrue also. So, and I don't drink and drive. I don't drink. I'm on probation for driving while impaired. So
When
I
did
don't
you
know where
get
she's,
last charge? 2022 or something?
yeah, I
Great.
was, yeah,
The driving was 2022. You were convicted in 2023
yes, yep,
and you're on probation and you are tested.
yep.
Is this a random test?
No, it's every month, once a month, every time I go and see my probation officer. And I have dropped, dirty for alcohol 2 times in the past 14 months. So, that's the extent of that. Once was the day after Memorial Day weekend, this
Sure,
year. And then,
That's, I'm gonna tell you, that's unacceptable. You know you're going in to be tested and you're still dropping dirty. That's a problem, all right?
okay,
That's-
yeah, no, and I understand that. And that's why I went in front of the judge for that and I have to take 6 more classes, but I'm not drinking at all. So,
You're smoking pot?
yep, I have a medical marijuana card for my, tennis elbow and my, carpal tunnel.
So for your arm, you're smoking, like every day?
Yeah, it's because otherwise I'm not able to perform at work. So that's why I got the, medical marijuana card. But, and that's not, I don't know where she's getting that. It's out everywhere and I smoke around my kids, because that's untrue. I do not smoke around my kids and I do not, leave it out. It's always in my car, if anywhere, or in my bedroom.
All right. Well,
So,
you do understand that what I have done in the past is basically to protect Mackenzie and
Right.
Mackenzie's ability to play softball, because Mom, you made a really bad decision, moved, tried to take her out of here. She was not going to be able to play. And this girl, I remember her vividly saying, I probably can't go to college because I don't have the money. I hope to get a scholarship, and the only thing I'm going to do is through softball. And I thought that was a really noble thought for her. She's trying to get there. She would like to get there. Ma'am, I assume that you are going to help her do as much as you can to get there. Is that correct?
Yep.
All right. Well,
Can I talk a minute? I'm sorry.
go ahead.
This whole case, actually, they told me I had to fill this form out too to change for the custody. My daughter was at his house while he was working his 4 jobs.
I understand, and I've read that. Okay, I can't undo that, and I'm not going to necessarily blame him. She let the kid in, knowing Dad was not there, and this kind of stuff. All right, I'm not, and I'm not going to blame her. It's an awful event, and I hope I hope they arrest the kid for it and do something appropriate. But I'm not going to necessarily hold him responsible for it, because he was at work, and she knew he was at work, and she let the kid in, and he does have to work, and he does have to work.
Yes,
All right,
not the
So
agreement though.
go
Parenting,
ahead on to some other avenue if you want to.
that's why I'm here. That's why Judge Hillary told me to schedule a hearing. He okayed this because of this. This is why I'm here. This is the point of this thing today.
Well,
And I got more to it. I added to the other page section of the 4-page letter of why this incident happened, why it shouldn't have happened, why he was not supposed to be working those extra hours. As you said in our courts before, he is not to work. Once he has Kenzie, parenting needs to be done there. And you said he is not to work the PM jobs if he's going to have her there. And he did. But he only worked 4 jobs, and it was overnight jobs too. It was a second shift where he got home at 4 a.m. My
I
kid was
understand.
home.
I understand. He's basically told me all this. Okay. He's told me he works a lot so that he can provide and whatever. I mean, that's,
Not providing for
and
her.
the fact of the matter is he was working. She let him in. I don't know. I'm not blaming Mackenzie either. All right. It's a real bad situation. It could have happened anywhere. Even if he was at work at another job that he's got a full-time job and stuff. Kids do stuff that are stupid. All right.
Parents.
And we'll see. And quite frankly, I wouldn't throw too many stones, because if she's living with you, things can happen. I've been a parent. We've all been parents. Okay. Things can happen. Kids do things that they shouldn't do. So the bottom line is that it wasn't my intent to change custody. It was my intent to not change the schools, which made him by default having to have the child there. And you know that. I told you that when we were everything. You could have, if you'd have moved back a year ago, you would have been there, and she might not have been molested. So it was her desire, and I'm not trying to make you feel bad either, all right? But you realize that you set that up also. So the bottom line is, I don't think there's any reason that, Mackenzie would not be in your custody. I'm trying to see if there was any, immediately attend school in person, reason stated on the father. And I gave him parenting time commensurate with her going to school. You had the weekends, all except 1 out of 4. I did give an order, he's not, but that's in October of 2023, not to consume alcohol. I don't know if he has or not.
He had the kids Memorial Day weekend. When he dropped dirty the next day, he had my children that whole weekend.
All right. And that's
And he-
not, and that's not a positive, sir. And I've told you, you being on probation and still testing positive is a real problem, right? It was just this last Memorial Day you're talking about?
Yes,
That's
Yeah, it was just
unacceptable.
what,
Yeah,
that
it's
was,
not acceptable
I
to
know,
say,
I have no,
but it's not acceptable to say, yeah, it was Memorial Day. Yeah, it was a golf tournament. It was a
no,
wedding.
I was
It
just,
was this or
I was
that.
just referring to the time, the one.
I know, but you said you tested
time
positive
that it
twice.
happened.
That has happened, and that gives me real concern about it. The custody will it never was changed, but it will be according to the judgment of divorce, where I believe there is joint legal custody, the domicile of the children, whatnot here. Custody of the physical, plaintiff shall have physical custody of the minor children, just as it was in the original divorce. That is based on your statement to me that you're gonna be back so that she can go to school at Thornapple Kellogg, ma'am.
my stuff's already moving into the house now as we speak.
Right, and you understand that that's based on, I want Mackenzie, she's a senior this year, isn't she?
Yes,
I want her to go to Thornapple Kellogg. The question, I guess, then is, since you have extended parenting time, whether or not he should have some parenting time with the kids. And at this point, it's gonna be somewhat limited, to like day visits on the weekend. At this point for right now, so you can do more, but again, not violating for drinking when it was strictly prohibited, just does not sit well with me. I have
And-
run Miss
and
Martin through the ringer, some things, that she did that was inappropriate, and you now have done something that's inappropriate, because right after that is when she went and got the ex parte order to keep Mackenzie and your child. So, at this point, I think, I will allow, are you off on Saturdays or Sundays, sir?
yep,
All right. And ma'am, you're gonna be much closer now, right?
Yes.
For an exchange. All right. Just on a temporary basis here for the next 3 months or something, he'll have parenting time with the kids. Does every Saturday or every Sunday work better for either of you? Just 10 till 7 o'clock on a Saturday or Sunday.
so I don't even get
Sun-
them overnight.
Not right now. You violated my order. All right? You violated a real important part of my order, which was drinking. All right? And I'm gonna require that you're gonna be able to show something from somewhere that shows drinking is under control, because you violated the order I did on last October.
Okay.
And I put a lot of trust in you with that, and
Yeah.
you've had a drunk driving that's in the past, but you're on probation. How long are you still on probation for, sir?
They extend it for 6 months for that,
So when are
Yeah,
you off probation?
February 2025. Or whenever I pay off my fine, she says, so.
Well, I don't wanna keep you from your kids, but, which you have been, but, would you
Right.
prefer Saturday or Sunday right now? And it'll be every week, so you can see your kids consistently. I might allow even an evening, a week from after school till, I don't know, 7 o'clock or something like that. I want you to see your kids, but right now it's not gonna be overnight. So,
Okay.
ma'am, Saturday or
Yeah.
Sunday?
Sundays work better if he's gonna do it every weekend, so we don't have to, like, if there's something going on, I'd like to, not conflict each other's schedule.
All right, sir, can you do every Sunday?
Yep.
Every Sunday,
can I ask that, after this meeting, that Ashley gets Mackenzie to her tournament that she has today
She won't be going today.
for softball?
Okay. Do you know when her tournaments are and stuff like that, or your games are?
I do, yes.
Yep,
I've been.
there-
Oh,
She's got one more weekend. Next weekend is the last tournament of the season.
Go to it. I'm not prohibiting you from going to any of the tournaments or anything like that.
Yeah, I've been to them, but she hasn't. The first tournament of the year, that week that she filed for the ex parte, she kept Kenzie from that tournament, and hasn't allowed me to take her to any.
What I'm doing. Mackenzie's my number one concern. All right. And I want her to play softball. If she can get a scholarship to go to school, a college, that will be fabulous. All right. And I want her to go. I want Mr. Bauman to know when they are. He can go, he can be there. He can see if the next tournament next weekend or something is goes through Sunday, well, then that's time that he'll have to spend time there. She doesn't have to miss a softball tournament to visit with her dad from 10 till 7 on Sunday. All right. But that's what it'll be. However, the other child, Sophia, can be with him at that time too. All right. That's the way it's going to go. How about I mean, sir, what you say you get off at 3 o'clock, don't you?
3:30, yeah.
3:30. You can pick up the kids on Wednesday from 4 till 6:30, have dinner with them, that kind of stuff.
Yeah.
And so you know what time the kids get out of school?
yeah, I don't,
Yep.
I don't, I have to go still file for Sophia to go to Byron Center schools through the system. So I don't know that time either. And then, Kenzie, they haven't announced it.
All right. Well, I mean, I'm not sure if you get off soon enough to pick up the kids from school. If not, then you pick them up from her house. Otherwise, from after school or 4 o'clock. I'm just going to set that time. If obviously if she doesn't get out of school and get available until 4:15, then that's until 7 o'clock. That's just on Wednesdays. I want you to see your kids, but I'm not trusting you with overnight at this point. You can take them for dinner. You can do what you want. Do their homework with them. Do that kind of stuff.
Also, sir, one more thing. During when all this happened, when I found out about he took my kid from me on my parenting time and told me he wasn't returning her. I have texts and everything, and I had to go get her. I'm letting you know he took my
I never said that I wasn't returned.
supposed to drop her off at 5:30.
What is the purpose of this? What is the purpose?
He violated my
You real-
parenting. Told me if I ever did that, I would be in jail.
If you think he violated, you can file something with the friend of the court. I don't do anything on that here. You can do that and ask for makeup, but he has just lost a ton of time from it, and I don't know what makeup you would get. This sounds to me like you're just trying to throw one more dart at him. He's already lost a lot. We'll see what happens down the road. Every Sunday from 10 a.m. to 7 p.m. Do you have a license, sir?
Yep.
Yes?
Yes, sir.
Restricted.
Oh, all right. Okay. I was just worried about, transportation every Wednesday, 4 till 7. Good luck, everybody. Take care. That, I guess that kind of sets aside the ex parte because I'm allowing parenting time. At this time, custody goes back to you, ma'am, as per the regular order. What?
Do I have to file for the child support to go back to normal too? Because
Well,
it's inflation.
and because of all this, we'll refer it to the friend of the court for child support.
Thank you.
Good luck, everybody.
Thanks.
We're adjourned. All right, thank you. Ms. Brown is represented by Ms. Striegel, Mr. Casantos, Mr. Van Eldern. It was a motion filed by the defendant regarding custody and parenting time. There is the only custody order in this case. I mean, I'm kind of short circuit some of this. Is from a DS order that was entered, a judgment of support, a consent judgment of support, and that says right in there that the mother has initial custody of the child without prejudice to the determination of either party's custodial rights until otherwise determined by the court or agreed by the parties in writing. That tells me that they don't really have to meet proper cause or change of circumstance. It's just there, and if either party wants to contest it, I have to have a hearing on it. that's the long and short of it, all right? So all the things regarding custody and all this kind of stuff, accusations back and forth and all that. I have to have an evidentiary hearing regarding custody because that's the only custody order that's in there and says that is without prejudice to determination of either parent's custodial rights. So, if anybody wants to chime in on that, I don't know why, because I'm telling you, I gotta have an evidentiary hearing. But I'll listen to you, not for long. So that pretty much takes care of that. Do both of you agree?
I don't disagree with you. No, I agree with that.
I agree with that as well. Thank you.
So we're gonna have a evidentiary hearing. My question is, would it be best at this point to, I don't do this very often, but because of all these allegations back and forth and whatnot, and her, I mean, she does talk about child support and why doesn't he pay and all this kind of stuff. And things there. I've read your response, Mr. Eagle. And I understand it, but either I'm gonna start, I need to set at least a minimal parenting time schedule right now. There's a 15-year-old and a 10-year-old. I'm inclined to send it to the friend of the court so that they can give me some help. Do either of you have a problem with sending it to the friend of the court?
I do not.
I don't have a problem with that.
All right, then, what about, it appears that mother does not have much in the way of financial ability to pay for that. Is that a fair statement?
Yes.
It's $150 from each. But quite frankly, if I'm gonna waive the fee for mother because she doesn't, I'm told that she doesn't work because she has some medical issues. If I'm gonna waive it for her, I'll waive it for both parties. Mr. Van Elderen? Any thoughts on that?
No, I have no issue with that. Thank you.
All right, we'll send it to the friend of the court. You guys know what's gonna happen with that, objections or whatever that come through. Okay,
Can I, just to ask a matter of housekeeping, is that going to be on all issues, including support, or is that just the custody that you're sending it to?
oh, no,
the
I'm
court?
sending it for custody and everything, okay?
Okay,
The support will just be kind of an offshoot of that, because depending on what custody and what parenting time is, we'll certainly make an appropriate determination
Okay.
as to what support is at that time.
okay, then I won't file a motion on that issue. Okay, thanks.
All right. What do we do in the meantime? It's a couple months at least process.
Well, that's the concern we have, is him having parenting time. I don't know what happened at
You
this.
understand, I'm not gonna stop him from any parenting time with the kids. That's
Well-
basically terminating his rights right here, okay? I'm not gonna do that. I'm not gonna give him, 50-50, and I might not do even every other weekend overnights, but I've got to have something out there where the kids can, have some type of relationship with them.
What about this? What about if we give him some time, like say on a Saturday or Sunday? I think that, I haven't talked to my client, but I think that'll work with her schedule.
Well, she's gonna have to work with the parenting time schedule, quite honestly, okay? Mr. Van Elderen?
Yeah, I was thinking, I mean, I understand they don't want to have overnight parenting time and that's fine. My client, I've talked to him and he's not pushing for overnight parenting time until, friend of the court has an opportunity to go through all of this and determine what's best long-term. But in talking to him, I think what would be reasonable would be like every other weekend, Saturday and Sunday for, a period of time, 6 to 8 hours or something like that, so that he can start to rebuild this relationship.
Well, I like to, but you can make some, ma'am, you can shake your head all you want, but stop. He's going to get parenting time. And my thought is either every other weekend like that, I would just as soon pick a Saturday or a Sunday from 10 till 6, that he gets them each week to build some kind of a relationship so that he can see him frequently. He's not gonna have them overnight. It'll be 10 o'clock till 6 o'clock on every Saturday or Sunday. The two of you can tell me which day works better. Or do you really want just the every other weekend on Saturday and Sunday? I think it's important to get more frequent time so he can start to build a relationship. Otherwise, I go 2 weeks and he's got a couple of days, he doesn't even get overnights, and then he's gone for 2 weeks and that kind of stuff. So,
So I do know, so my client does work a lot of weekend, his schedule is a lot of weekends. Santiago, you can jump in. What is your work schedule right now?
My work schedule for the past 4 years, it's been Friday through Sunday, 6 a.m. to 6 p.m. I only work 3 days out of the week, and then I get the 4 hours because I give up my weekends. I get 4 hours, so I get my 40 hours.
Okay.
No,
You
no
work
overtime.
Friday, Saturday, and Sunday, so you can't even visit the kids on those days.
No,
So would you be
I
able
was-
to do like a Monday or a Tuesday as long as because the kids aren't in school right now, at least until school started, and then we can try to figure out afternoons or evenings or something like that until FOC can put something together? Or are you able to take and move your schedule around at all in order to accommodate?
He said he's worked that schedule the last 4 years, so I guess what I will do is suggest that until school starts, that he has the same thing on Monday from 10 till 6. Does that, I assume that is, works in the mother's schedule. You can have Mondays 10 till 6 each Monday. When school starts, you're gonna be limited to like an evening a week. And maybe it's best if we just do every Wednesday and then switch it to Wednesday from after school until 7 o'clock.
Okay.
Of the friend of the court. All right.
So he'll beginning July 31st, next week, Wednesday, he would do 10 to 6. And then once school starts, it would be after school until 7.
Yes.
Okay. Thank you.
Ms. Striegel, I will give you can say something if you want. I know you're writing down so that we can get an order in here, but you understand what the schedule is?
Yes. Yeah, it's Wednesday, every Wednesday until school, 10 to 6, and then after that, it's after school to 7, every
Yes.
Wednesday until the FOC recommendation.
All right. Somebody's gonna draft that order.
I can draft that order. Thank you.
All right. Anything else, Ms. Striegel?
No, Your Honor.
All right, thank you both very much. Have a good afternoon or good morning, or a
You
good
too.
day, everything. I don't know where we are. Good luck. Thank you.
Thank you. Thank you, Your Honor.
Yep, take care. Bye.
Wait till the front of the call. Number 9? Number 9? Why does number 9 settle a lot? The song off the Beatles' White Album, number 9. Yeah. Good morning, everybody out there in YouTube land. Those up in Mackinac, hope you're having a good day. Anybody else? Regular listeners? Cheryl, Sharon, Missy? It's a matter of Ladewig versus Edgerly. Both parties are present via Zoom. This is a motion made by the mother regarding Ashlyn. There is a custody hearing right now set up for the 7th of August for the eldest son, Emerson, who is 16. She now says that Ashlyn's in emotional distress, that dad tricked the kids into believing her partner was physically abusive. I don't understand that. I don't know how he tricked them into it. Ashlyn is self-harming at dad's house, she says that the dad makes fun of kids and all the kids and stuff like that. Ma'am, he might be a jerk, but I don't know that is enough for a change of custody. You say Ashlyn's on the spectrum. You want me to talk to the child? I do not do that prior to the requirement in the best interest factors. I'm not going to talk to kids at this point. And you want her included in the evidentiary hearing. That pretty much says it all, doesn't it? What you want?
I mean, I think it goes beyond him being a jerk. Like he's calling a 13-year-old girl.
Hold on a minute, sir. You can't be driving while you're on.
Yeah, I was in a spot where I had to. I'm focusing on the road. I had to pull out of a job site that I was at.
Ma'am, I can't have him on Zoom, so we got to wait for him to stop.
All right, I'm almost right back where I need to be. I was sitting at somebody's house, so I didn't
That's
want
fine.
to,
I just need you to stop. I can't do the motion
I'm
while
pulling-
you're driving.
I am pulling over right now.
Okay.
Here we go. Thank you, sir. I apologize.
No problem. All right, ma'am, now you can go ahead.
I said, I think this goes beyond him being a jerk. You don't call a 13-year-old daughter a worthless. Like that is above and beyond being just a jerk.
Your Honor, so when all of this happened and Sean picked up Ashlyn, I tried to call Sean to give her more context before I found out that she was on her way to pick up Ashlyn. There is a lot more that goes into this, but the last time we had a conversation about the girls manipulating the situation that I came in and apologized for, you mentioned that we need to be able to communicate. So that's what I tried to do. Well, how all of this actually started was the fact that Ashlyn is obviously 13 years old. She has started her womanly time of the month,
Yeah.
and I asked her to take out the trash. She doesn't do that. So Ashlyn, I said, look, it's your time of the month. I ask you to take out the trash twice a week, and that's a problem. Then it turned into this, and she started yelling at me. And yes, I said things about her mother, not her. I would never call my daughter that because I do understand she's on the spectrum. I have another child on the spectrum. I myself are probably on the spectrum. I would never call my daughter anything. Yes, I said her mother's a worthless. And because she's like, I want to go live with my mom. I said, why? She doesn't have a job. She doesn't do anything except, I said things I shouldn't have. I was emotional about it because I had a child yelling at me. I stepped out. I tried to talk to Ashlyn about it, and it wasn't happening. So I decided to walk away. Next thing you know, Ashlyn was missing from my house, and Sean was pulling into the church parking lot. And when I tried to talk to her about it, she ignored me and drove off. I actually did file a police report because she came and picked up my daughter on my parenting time. And the problem is lack of communication. And at the end of the day, the only reason Sean cares about this is retaliation from when the kids were with me that I've already apologized for, and the fact that she's about to have to pay child support for a child that she abandoned. It has nothing to do with Ashlyn. And she can deny it until she's blue in the face, but her own son doesn't even want to communicate with her.
Let's be
When
real.
I went to go pick up, Sean, can you please stop talking? Let me finish. You had your
Oh,
time.
wait a minute. This is going off the rails. All right. I understand your position. All right.
I'm trying to give you context.
I understand. I've got a lot of emotions and I understand what your context is. I understand that we're going to have a custody hearing for Emerson in less than 2 weeks, I think.
Yeah, I submitted all the paperwork for that.
Anything else you want to add, ma'am?
Yeah, I have not asked for child support for Ashlyn. I don't have a problem paying child support for Emerson. The reason Emerson is not at my home is because he is violent.
This is,
And
This
that
is about
a
Ashlyn.
and sir, she did not interrupt you. Do not interrupt. Do you understand?
Yes, sir.
this goes beyond. The problem is his emotional responses. And I have heard from all three of the kids about how he degrades them, how he calls them horrible names, how his girlfriend calls the girls horrible names. Like, you do not call a 13-year-old girl a worthless. And this is emotional abuse. This is what he did to me during our marriage. This is what he is now doing to my daughters. Like, they do not want to be around his violent household, with the constant arguing. Like, this is what happened last year was he convinced the kids that my partner was physically abusing me. So they were afraid to come to my home. Once they learned that that was not true, then it's a totally different story. So
Your Honor,
I was robbed of months of parenting time because of this. He has done nothing but perpetuate lies and misinformation to try and convince the kids to not want to be in my household.
Your Honor, this is the same crap she pulled in our divorce. She said the same thing. She actually had a point when early in our divorce, I don't know, 10 years ago, that I think it was 2013. So, 11 years ago, where I actually had supervised visits and then turned around and gave me 50-50 custody. None of this is true. And even if it were hypothetically true, what I was in our marriage, I'm not the same person. I took a child, I will use Emerson as context. I took a child that was being abusive, being drugged to the point where he has now been in trouble. He's being removed from probation, off all medication, and he's not been a problem. So
We'll be in here on that to determine what is the appropriate,
I'm just trying to give you
custodial
context.
arrangement. On the 7th of August. If you guys are coming in without attorneys, you're making a big mistake, but we'll have that hearing then. I'm not going to include another child in that hearing at this point. I don't think there's any preponderance of the evidence. I understand what, I'll hear some stuff, and ma'am, if you wish to renew your motion on the 7th after we have testimony or whatnot, and wish to renew your motion orally at that point, I'll listen to it, but I'm not going to add it. It's way too late to add her anyhow, since there should be sufficient notice to defend and everything on it. The one that we're gonna have is on August 7, is for Emerson. I don't find at this time a preponderance of evidence that there is a change of circumstance or proper cause to have another child in there, sir. Like I say, you might be a jerk, and if you're using that kind of language and stuff around your daughter, you say you don't, you say you've learned your lesson and whatnot. I don't know. But I'm going to deny the motion for Ashlyn. We'll see both of you on August 7. You don't
Your
have
Honor,
attorneys, you're making an awful mistake. Good luck.
Your Honor, there's something else that was added in that I just found out recently. She attempted to switch our daughter's school without my
He's got joint legal
authorization.
custody, and effectively, ma'am, if he objects to it, we gotta have what's called a Lombardo hearing.
What's
She was
Lombardo
in
hearing?
Hudson.
You're not.
She was in
I'm not
Hudsonville
gonna
last
educate you, but
year.
I'm telling you, if you change kids' schools and he objects to it, we gotta have a hearing on it.
He did that to me last year and you said
I
nothing
actually have
about
your
it.
text. I have your text authorization. Actually, I have a screenshot of that. So I will, as of right now, Ashlyn needs to remain in the school that she was in last year.
What is the
And not
school
move
she was in
schools.
last year?
Hudsonville. Ashlyn has moved schools way too many times. I'm trying to create a stable environment for them, and Sean ripping them into another school would be very detrimental to her.
She requested, she wants to
She's
move.
13. She's trying to do what you want her to.
You are the parent. We'll set up an evidentiary hearing called the Lombardo hearing to determine what's the appropriate school. All right, what do
All
you?
right, so when can I exercise my parenting time?
Whenever it's set for right now.
She
Okay,
does not
and if-
want to, she does not want to go
If you're
over there.
if you're denied it, file with the friend of the court. You understand?
I already have. I
Well,
plan on doing
And
it.
eventually, they'll bring it to me to potentially hold Miss Garrigus in contempt, and we'll deal with it at that, but I'm not going to, I mean, you have to show up, and if it doesn't occur, then you file with the friend of the court, and I'll deal with it on the appropriate date and time that they set it for. I'm not changing anything.
I did Monday. Okay.
Good luck. Thank you. We're adjourned. We'll see you on the 7th. It'll probably go great on the 7th. With neither of them having attorneys and.
So we're doing the one bar here different.
Yeah. Well, Miss DeHaan, thank you for the message you sent me.
Did you call Kellen?
I have not yet, but we will. We're just trying to figure out when and if we need her.
Good. I'm so glad. Hopefully
I'm quite impressed with the stuff that you sent me about her.
she's wonderful. In terms of training, Apollo is an incredibly well-behaved dog, and he can be off leash and not wander too far. And it's all very positive. She's just a wonderful human being. I think you'll really like her.
She obeys better than your husband?
Yes. I didn't even need to think about that one. Absolutely.
Send him to training.
Right.
All right. Sebelak, Mr. Sebelak?
They're together.
Oh, you're together. All right. Good morning, the two of you. And we also have the Kent County Prosecutor, Ms. DeHaan. She is here wishing to enter a judgment of support that calls for $0. She is just required to do this through the state of Michigan. Both parties are there. You don't have any objection to entering this judgment of support, do you? The only reason that support would come into play is if you guys separate and then somebody has to start paying.
Okay. Right.
Do you have any objection to this order?
Nope.
All right. Well, I hope it never has to come into play. I hope the two of you stay together and live happily ever after. All right. Because you got a daughter there. Okay. So, Ms. DeHaan, you can send that to me through DocuSign.
Fantastic. Thank you so much, Your Honor.
You didn't want to add anything, did you?
Just that I had been in contact with Miss Soto and we had talked. Mr. Sibilak, am I saying it correctly? Hopefully.
Close enough, C Black, yes.
C Black. I'm assuming that he was very busy working. Every time I tried to call him, I was unable to get a hold of him. That's the only reason for this hearing is because I was
That's
unable
fine.
to get a hold of them at the same time for signatures.
But he's here and both of them are smiling, and that happens very rarely on a Friday morning.
I will take it happily, Your Honor.
Good luck. Thank you to everyone. Have a good day. EP Edwards versus Delbridge. Both parties appear to be on Zoom. Mr. Delbridge, you have a camera and can you hear me?
Yes.
And Miss Edwards, same to you. You're on mute, but looks like there you are. You can hear me all right, ma'am? Uh-oh. She's got a nice smile there, but is really frozen and unless she just continues to smile. Not many people smile at me for that long. There we go. Can you hear me all right, ma'am?
Yeah, I can. Can you hear me?
Yes, I can. Mr. Delbridge, turn on your camera, please.
One moment.
This is Mr. Delbridge's request to set aside a default paternity order that was entered 1/26/22. Are you asking for a DNA test based on that?
Yes, sir.
Miss, well, let me ask the two of you. Miss Edwards, do you have any thoughts on him taking a DNA test for this child?
To my knowledge, when Mr. Delbridge had Chloe, the child in question, during Christmas, this past Christmas, it was to my knowledge that he got a DNA test and that she is not his. So I am fine with him doing whatever he needs to do because I wanted him to take a DNA test from day one and he refused at the hospital.
Yeah, I mean, I'm not impressed with this case was filed and I don't think you cooperated with it, sir, and ended up with a default judgment of paternity just because you didn't do anything. And so now you're asking to come back. Ms. DeHaan, do you have any, it is within the 3-year period of time after it was entered. I'm kind of thinking, sir, I mean, obviously, if you're not the legal father, you're not going to see her anymore. You saw her at Christmas, apparently, and this kind of stuff. You will have absolutely no rights if it comes back that you are not the father.
I understand that.
Ms. DeHaan, do you have any thoughts?
Briefly, Your Honor, I did read Mr. Delbridge's motion. I will say that this matter was served properly via alternate service. The documents were mailed to him via first class mail at the exact address that is listed on his motion. And a copy was tacked to his house as well, or place of residence as well. I would be happy to say that the state could do that genetic testing for the parties. However, the only requirement that I need would be to know who the other potential father is at that point in time. If I do have that information from Ms. Edwards, then the state would be more than happy to facilitate the genetic testing, cover the genetic testing costs, and do all of that. But I do need information from her to do so.
Ms. Edwards, you don't have to tell me right over the internet if you don't want, but do you have another person that could be the father?
Yes, his name is Brandon Lee. I have no problem giving that information.
All right. She'll want some information on address or if you know any contact or any way that they can, whether it's through a parent.
I would just like to say, Your Honor, I do not have any other information. I do know his full name is Brandon N. Lee, but I don't have any other information on him. I know he graduated from Ottawa Hills High School, but Mr. Delbridge actually put his hands on Brandon, and he has since blocked me, and I have no contact with him since.
You know how old he is?
He would be 34 years old.
34 years old, graduated from Ottawa High School. I don't know.
Excuse me, Your Honor. I don't even know who this Brandon person is.
You're not part of this right now, unless you don't want to take this test. Okay. She is giving the information so that there is the potential, because Ms. DeHaan said she's not even going to do this unless she has a possible alternate. She has an alternate. I'm just trying to find as much information so that the prosecutor can possibly locate this person. All right. You do have information, Ms. DeHaan, that he would have graduated probably when he was 18 from Ottawa High School. You might be able to track that down. So with that information, you're all right with, facilitating a DNA test?
How do you spell his last name, Miss Edwards?
L-E-E.
And then what's his middle name?
I don't know what his full middle name is. I just know that the initial is N.
N, like in Nancy.
Do you know
Yeah.
whereabouts he may reside?
I went to school with him at Ottawa High School in Grand Rapids, Michigan. I would assume he's somewhere there, but I mean, you know, people move. I don't know.
Mhm.
I haven't spoken to this man in like 4 years.
Typically, Your Honor, there is more information that we require, but I will leave this to the court's discretion.
Yeah, and you say you haven't spoken to him in 4 years. 4
Correct.
years, 4 years ago, was he still living in the Grand Rapids area?
As far as I knew, yes, sir.
All right. Did you have any like contact when you spoke to him in person, or is this through the internet, FaceTime, this kind of stuff?
The last time I spoke to him was at the hospital when Mr. Delbridge put his hands on the man.
All right. So at the hospital at the birth?
Correct. Which Mr. Delbridge states in the paperwork that he was not at.
All right. We don't need to go through that. I'm trying to
Just-
get to the bottom line.
Your Honor, I apologize. Miss Edwards, was a police report filed after that incident occurred?
No, ma'am. No.
I don't know if there'd be any hospital information that you could get that indicated he was there also.
He was not inside the hospital. That happened outside the
all right.
hospital. But
Well,
Mr. Delbridge was inside the hospital when I gave birth
Ma'am,
to Clark.
can you do any? I'm going to ask you to please see if you can do any type of asking friends or anything if they may know where he is. He must. You were friends with him and stuff like that. So ask if anybody, and if you do, if you could please contact Miss Dehaan, Dehaan, at the Kent County Prosecutor's Office. The more information you get, the better, because it appears that Mr. Delbridge very well might not be the father, and they are going to try and find the true father and make him father. Okay. So,
Okay.
Ms. Dehaan, I would like you to facilitate the finding of it, and maybe we can also find Mr. Lee. All right.
Fantastic, Your Honor. I'll have that done. Your Honor, would you like me to draft the order following this hearing?
Sure. Put it this way, Miss Tracy would like you to draft the order.
I will do it happily.
All right. All right. If you will remain on, Ms. Dehaan, we have one other issue briefly, and then I think there's another one that you're also involved with. Okay. And
Thank
this one is relating
I
to
can't hear anything.
regarding Elias, is what you're asking for. Is that correct, Mr. Delbridge? Mr. Delbridge? Hello? The fan's running behind you, but can you hear me? Yeah, sir, did you disconnect or what? Ma'am, is there any kind of parenting time order regarding Elias?
So I believe that's the other issue that we have. We need to put in writing a parenting time order and stick to that agreement. I actually recently have a police report because me and Mr. Delbridge
I can't hear anything.
Well,
there's no volume on my end. I can't hear anything.
You've heard me before this, haven't you?
I'm sorry. I
Suddenly
just
he
got
can't hear.
Oh,
I
he
understand.
can't hear me.
Hey, I can't hear anything.
Can you hear me now?
I can't hear anything.
I understand. I can hear you. You type. Gonna log out and log back in. We're not gonna wait too long. We'll just renotice this if we have to. That, Ms. Edwards, all I'm really asking is there is no written parenting time agreement for the court to enforce regarding Elias. Is that correct?
That is correct, but we would like to set one.
All right, because he lives in Arizona.
Correct, Your Honor, and he believes that he should get all of
Okay, I can
Christmas
hear him.
time.
You can hear
Right.
now. All right. I just asked her if there was any court order for parenting time, and she just told me, no, there isn't, but the two of you need to get an enforceable court order. You
Absolutely.
agree with that, right?
Yes, yes.
All right, and if the two of you cannot agree on it, then I'm either gonna have to have a hearing or more likely probably send it to the friend of the court to see what they think is appropriate for a parenting time order in that matter.
Okay.
They can investigate it. I mean, the summer's, nothing can happen by the end of this summer anyhow. And
Now connected to whom?
and you're in Arizona, your parenting time is gonna be limited to time off of school and things like that. So
Absolutely.
unless the two of you can agree on a parenting time order, then we'll send it to the friend of the court for them to look at it.
Your Honor, can I say something?
Yeah.
I know for a fact me and her are not going to be able to agree.
All right.
Since our last hearing, I was denied parenting time until just this last winter. I didn't see my son or Chloe for over 2 years.
Well, you're asking to be not Chloe's father anymore.
Well, yeah, but I was just saying at the
All right.
time.
I understand, and that's why I'm sending it to the friend of the court, because you guys aren't going to be able to agree. We'll see what the friend of the court says. All right?
Your Honor.
Yes, sir. Yes, ma'am.
I live in Mecosta County. So, I mean, no disrespect by asking you this, but would it be possible to move this case to Mecosta County? Because I'm an hour away even to drive to you, sir. And I don't have any problem showing up. But I also have 3 other kids, and I'm in school, I'm a working mom. I'm trying to handle my business, sir.
All right. Let me take a look at it. I don't think Mecosta is adjoining to the Kent County, I think, isn't there a county in between us? Is that Big Rapids?
Yes, sir. I am in Big Rapids, and you are correct. Macomb County is in between Mecosta and Kent.
Let me see about whether I transfer that. That's not really a motion before me today because it was not noticed. I'll take a look at it and see what we can do. All right.
Thank you so much. I appreciate that consideration.
All right. Thank you, everybody. We'll refer it to the friend of the court. You'll get notice. Please contact them with whatever information they request. All right.
Yes, sir.
Good luck. Thank you. We're adjourned. What? DP, matter of Leon versus Della Rosa. This is Mr. Della Rosa's motion for entry of an order. Basically, it's an order that makes him not father of the child in question here. There is a Miss DeHaan is on from the prosecutor's office as well as both parties. Ms. DeHaan, what is your thoughts on this?
Your Honor, I think that this is ripe for the best interest factors hearing to disestablish paternity. The last time we were before Judge Hillary, actually Michelle Smith-Lowe appeared on my behalf on that one. And genetic testing was done in this matter, and it was determined that the defendant is not the biological father of the minor child. However, we had been in contact, or at least attempted to be in contact with Miss Leone to determine who the other potential father would be in this matter. I have been unsuccessful in collecting that information from her, so I would request that she provide that today. However, I do believe that this is appropriate, and it is appropriate to have the best interest hearing findings done, Your Honor, at a time that's convenient to you.
Has Mr. De La Rosa had a relationship with this child, ma'am?
No.
Do you have, the prosecutor is stating, and we just went through this on a prior one, you list anybody? I mean, Mr. De La Rosa does not appear to be the biological father, so someone else must be. Can you give them the name of someone who could be potentially the biological father?
It's unknown at the moment, sir.
It's unknown.
I'm
at
not
the
sure.
moment. What does at the moment mean?
I don't know. I don't know who the father is, so. I thought it was Mr. De La Rosa, but apparently it's not, so I don't know who that is.
All right, then I guess at the prosecutor's request, sir, we'll have a quick best interest hearing and we'll schedule it for probably nothing more than an hour. Mr. Hahn, will you be appearing for that then?
Yes, Your Honor, I will do so.
We'll schedule a quick evidentiary hearing on this matter. Both of you will be required to appear as well as the prosecutor, and we'll see where we're at with that time. Mr. De La Rosa, you'll get notice of it. We do have a address for you. I'm not gonna read it all, but it's 2533. Is that correct?
Yes, sir.
All right, we'll send you out the notice. We'll get to the bottom of this quite quickly. All right?
All right. Thank you so much.
All right, Ms. Leanne, you'll be expected to appear also. Good luck. Thank you. We're adjourned.
Thank you, Your Honor.
When is this happening? I'm sorry, I'm having a
I'm
hard
gonna-
time hearing.
You're gonna get notice of when it's happening,
Okay, got you.
right? It won't be too far out there. So, good
right.
luck. Thank you.
Thank you so much, Your Honor.
And thank you.
Absolutely. Have a
Thank
great
you.
rest of your day and a
You
great
too.
weekend. Thank you. Bye, Tracy. Bye.
Who the fuck? I'm just saying, who was that? Light skin chick popped up.
Mr. Libet, can you hear me?
Yes, I can hear you, sir.
Brown versus Libet. Mr. Libet, how did you get noticed, Ms. Brown about this hearing?
How did I notice her?
Yeah,
I sent the notice to her address, the last known address.
when?
What day was that?
The day after we went up there and filed the paper, so whatever day we filed it, the very next day.
I want to say whatever day we filed it, the next day.
And you mailed it to her at an address, the last known address,
Yes.
which would have been, you say you filed it. Looks like July 9, so you'd have mailed it July 10?
Yes, sir.
All right, that's sufficient notice. She has not appeared at this time at all. This is a father's or Mr. Libet's motion regarding child support. He says he can't be the dad because he was in prison during the time the child was conceived. This is, but the order for making him the father is from 2019. And then there was a more recent UCSO in 2023. He wants extended time to file for ROPA, revocation of paternity, because of a mistake of fact. How you've known this for 5 years?
Yeah, I've been incarcerated for basically the 5 years.
People file stuff from jail all the time.
Yeah, but that's because some people have resources, the outside people that can help them. It's harder when you, no, it's harder when you don't have resources outside.
You don't have family anywhere?
I mean, I have family, but they didn't help me when I was in prison.
You didn't tell them, hey, I'm not the child's father? I mean, you've been getting a lot of notice about this. How long have you been out? I mean, I know that when you say.
I just got out April 25th. Did you hear what I said to you? I said that my family didn't do nothing for me when I was in prison, so how would I let them know anything?
Yeah, but
I didn't have no money. I didn't have nothing.
I get stuff from prison all the time.
Yeah, that's some people that got money and stuff to send stuff. I didn't have no money. I didn't have no money to even get no hygiene. So how would I have money to send you something?
So how long have you been incarcerated?
I've been in prison in and out since 2013.
Okay, well, when you're out, why didn't you do anything?
I was doing it. I was trying to figure out how to do the processes. The whole point of the moral of the story is I'm not the father of that child. It's impossible for me to be. I was in prison.
Legally, you are the father, whether you are the biological father or not. Legally, you are, and it's from 2019.
Okay, but I'm telling you, I was locked up from 2013 to 2018. I got records of that. So it's no way that I can be the father to no child that was born in 2017 that got conceived in 2016. That's what I'm telling you.
But the act says you got 3 years after the child's born to file.
I was in prison.
Okay, but you were in prison during some of those times and you just didn't file anything.
So what are you saying? Are you saying that just because I missed it, I couldn't file or I didn't file the right time, that I had to take care of I'm getting charged for a child that's not mine?
What I'm saying,
not mine. It's clearly,
what I'm saying is I got to follow the law. All right, I got to follow the law. I have to follow the law, and the law.
So what is the law then? Because the law, if a child is not mine, why should I have to take care of the child? If the child is not mine, it's not mine. It's not mine. Just because a female says that it's mine, and y'all send me a paper, and I couldn't mail a paper back to you, that means that it's mine, and I have to take care of it. Y'all taking money from me that I barely had to take care of a child that's not mine. What are you not understanding? I was in prison from 2013 to 2018 in the MDOC. It's no conjugal visits. It's no way that my dick could have went into her vagina and made this baby. That's what I'm telling you. Regardless of the fact if I didn't mail something out, if I did mail something out, if I wasn't supposed to mail something out, if I was supposed to mail something out, it doesn't matter. The point about it is, it's not mine. That's the whole point. You sit here keep trying to tell me that I have to take care of, or it has to continue this way. You are the judge. You can overrule certain things. It's clear fact. Anybody can see that that child's not mine. Michigan doesn't do conjugal visits. So there'll be no way that we can have sexual intercourse to make this baby in 2016 if I was in prison. That's what I'm telling you. Anybody will see that. A blind person could see that. You know why? Because he can hear it. You can hear things that you can see, and you can see things that you can hear. That's the whole moral of the story. The baby's not mine.
The moral of the story is that in 2019, you were defaulted and it was found that you were the legal father. Whether you were the biological father or not, it was determined that you were the legal father. You have been in and out, and I can't get a straight answer, but clearly you've been in and out of jail and or prison during the time from 2019 until now. It's been almost 5 years.
No, I've been in prison since 2019. I got out in August, was out for only a month, went back to and got out and was only out for 3 months, and that was last year. So from 2019 until last year, I was locked up. When I filed when I called and did the other thing that you said, last year, and then I got locked back up for a year.
Stop. I am going to adjourn this motion for 2 weeks. The prosecutor's office is the one who set this up as a paternity order. I'm going to notice the prosecutor for them to come in on this also and make their side known, and then I'll deal with it. So we will revisit this matter 2 weeks from now, and I'll make a ruling at that time. Thank you.
All right, so 2 weeks from now?
2 weeks from now.
So from today,
Friday morning, you'll be back on Zoom. We'll see what we're going to say. We'll send notice out. All right?
All right.
Thank you. We are adjourned.
All right, so do I got another case to go to court with you about?
I don't know.
I should have another court date with for a child support lower the money that it's taking.
It's not in front of me today. I don't know.
Okay.
So we are adjourned. We'll see you in 2 weeks.
All right.
DC matter of Masters versus Lida. Both parties are present by Zoom. This is a motion that's filed by the plaintiff. There's a recent filing of a custody matter by the plaintiff, Mr. Masters. He's now asking for a temporary order regarding the children. He wants sole legal and physical custody. He says the children lived in his home the whole time. I assume, ma'am, you lived in his home also. Is that correct?
Yes.
So the two of you have lived together since the children were born?
12 years.
All right. And have you moved out? Because the motion really is mute.
No, I have not. I am still here because he has not legally evicted me yet. We still have to go to court.
So whatever happens, when is a hearing or something to be evicted? That's got to be
the 30th. Yes.
Next.
It's on next Tuesday on the 30th.
All right. Assuming somebody's going to end up leaving that place.
Oh, it'll be me.
All right. Where are you going to move to?
I do not know yet.
Oh. So you expect you're going to be out next week?
I guess I don't have a choice if that's what the judge says during our hearing.
Well, I mean, I'm trying to reach some kind of a understanding as to what to do with the kids. I mean, it's going to be tough for you to take the kids if you're moving to a bridge, under a bridge or something like that. I don't know what you're asking for.
I don't know either. I'm not the one that called this.
Well, I know, but something's got to happen with the kids, and I've got to figure something out. I can, at this point, pending you moving out, I can give a temporary order that gives physical custody to the father, joint legal custody at this point, I would say, and parenting time to be agreed upon. Ma'am, when you move out and you got a place to live or something, and if you can't agree upon parenting time between the two of you, I certainly will. It's clear that these kids have an established custodial environment with both parents, and it's because they've lived together for 12 years and the oldest child's 9. So I'm not saying that you wouldn't have as much right to those kids as him, but I can't. You're not giving me much as far as where you're going to go.
I don't have anywhere to go.
And if you live in a car, I can't have the kids be with you.
I know.
You debate yourself.
What was that, sir?
Nothing.
He's just trying to make me feel bad.
Yeah. That's not going to go very far, Mr. Masters, if you're making snide remarks. I'm just telling you right now. All right?
I know.
Can I mention something, please?
Mention something.
Yeah. Yesterday, when I was home with my kids, my 4-year-old daughter looked me in the face and said to me, "Dad doesn't care what you say. He wants you out of his damn house."
How does that help me make any kind of decision?
I just...
Here's what I got to do because I have nothing else to do. I'm going to issue a temporary order where the plaintiff, Mr. Masters, has physical custody. The parties are going to have joint legal. Parenting time will be as agreed between the parties. Ma'am, if you move out and you can't agree on having those kids a substantial amount of time, you come back in front of the court and I will see to it that if you have an appropriate place, you're going to get an appropriate amount of time. Now, the problem is both of you, he works till 2 o'clock and you work at night. All right. The greatest thing would be, for him to have him from the time, from, I don't know, what time do you go to work, man?
I go to work at 4.
Yeah. It'd be appropriate that he'd have him from 4 o'clock or whatever it is, until morning. The kids go to school. Because what time do you work?
He goes to work at 4:30 in the morning.
Yeah. Well, I'm going to tell you that as much as you may not like her or anything, or you might not like him, you guys better figure something out for these kids. If you don't, you're going to come in here and I'm going to do my best to figure it out, because I don't know what you're going to do with the kids from 4:30 in the morning until they go to school, especially Caroline, who will have to go to school. And I'd imagine maybe Alice and Olive are going to be starting preschool here, and you can't do it if you're at work. And, I just don't, what time do you work till at night, ma'am?
11:30-ish.
Because there's no good solution to this. You're going to share weekends and stuff like that. I'm telling you this right now. Each party's going to have every other weekend probably, because you're both off on the weekend, I think. But until then, I'm just going to give you physical custody with joint legal custody, sir, with parenting time as agreed. You got to figure something out on the best interest of your kids. All right. You're not going to get them just to yourself, Mr. Masters. She's part of this, and she is an established environment. What?
I do understand it. I want her to have just as much time. I really do. I just want them to stay at home. That's all.
At home, but they're going to have 2 homes now. I'm telling you. Okay.
I get that.
And so, as agreed upon, we'll see what happens. If you need to come back, ma'am, because if you can't figure anything out, I'll have to figure something out. I'm not sure what I can do, but as agreed, I'm not going to order any type of child support at this time. This is just a temporary order until we can figure something out in the future to make it something a lot more certain. So that's what the order of the court will be. Good luck. Talk it out, no matter how much this is going bad. Talk it out so that the kids don't suffer. Because I don't know how to say it. I don't really care much. But what happens with the parents, I'm worried about these kids, and they have to have parents who work together. Good luck. Thank you very much. We're adjourned.
Thank you.
PM Bonner v. Bonner. We have Mr. Colvin
drive you back.
representing the plaintiff, formerly Miss Bonner. And we have the Mr. Bonner represented by Miss McCallum. This is a motion filed by Miss McCallum seeking a temporary order and to expand the threshold hearing which this court has set for September 27, 2024. I did not find enough evidence, at least in just a Friday morning, to state that the parties had met Vidvarka. So I set up an evidentiary hearing to make that determination. Now, Ms. McCallum, you're saying, I want another bite of the apple. I want another chance. I don't know where you are. You can make your, I've read your statement. I've read Mr. Colvin's response.
Thank you, Your Honor. First off, there has been a recent incident this past week on Monday night where the police were called to plaintiff's house to deal with a domestic incident between plaintiff and the party's recently 18-year-old son who came to my client's house with the other minor child around 10 or 11 p.m. that night based on the party's son had gashes on his forehead and hand inflicted by the plaintiff, and they had gotten into a physical altercation. And this is not the first time that the minor children have shown up at my client's house when it is not their parenting time. It happened 8 times in the months of May and June. They keep showing up at my client's house saying they don't want to go to parenting time with mom. Most recently, the police were called and there was an incident report filed for this domestic incident between the party's son and plaintiff. There's clearly things going on at plaintiff's home, and the kids are not feeling safe there. And the fact that they're getting into physical altercations with their mother is extremely concerning. And we're asking the court for temporary relief pending the evidentiary hearing. Based on this most recent incident, the clients haven't been back to plaintiff's house since the incident on Monday. And the youngest is supposed to have parenting time over this weekend, and she does not want to go back to mom's house after
I'm gonna
watching.
go through this again with a 13-year-old and stuff. I've set up an evidentiary hearing. One of the things that came through was an incident on July 10, 2024, where the girl called and said, I don't feel safe at the house. The police went and found out that in fact it was because she wasn't doing her chores. Mom was not happy, took her phone away, and your client called the police on a well child check because she said she was, and in fact, it didn't appear to be anything. I don't have a problem with having an evidentiary hearing. I think it's important to have an evidentiary hearing. But, I mean, you're asking me to violate basically the upper court's understanding that I'm supposed to have some type of an evidentiary hearing to determine when there is a dispute in facts about Vidvarka. I didn't find it in the last one, and most of what your brief talks about is because, yes, her mother and her sister may not have agreed to that, even though they did. They clearly signed this statement and whatnot. I mean, that's what this hearing is about. And I don't know how long we have for it. What is it set for? 9 o'clock till probably noon. You're not going to get a custody hearing out of that anyhow. It is a threshold hearing. What bothers me a lot is also you're saying you want me to skip a Lombardo hearing and just change schools, and you know I can't do that. Why would you even suggest that I am supposed to skip that?
We weren't suggesting that you skip that. It would be part of the evidentiary hearing along with the other issues.
And you think you're going to put your proofs in 3 hours, and he's going to cross-examine in 3 hours?
Well, we're hoping for it to be the start of the evidentiary hearing on all issues.
It will be the start of the evidentiary hearing, and that if you show that there is proper cause of change of circumstance, we'll go right on and set a new date for a custody hearing. We'll set a Lombardo hearing. We'll do all kinds of stuff. That's what it's set for.
Yes, Your Honor. We would also ask for GAL to be appointed in the interim, given these recent incidents and concerns that have been ongoing with the children. I mean, they haven't spent parenting time with their mother all week because of this incident that happened on Monday where she inflicted physical harm on the 18-year-old.
Let me ask Mr. Colvin. Mr. Colvin, It's your chance to respond. I read your response.
Yes.
And-
Okay. Thank you, Your Honor. The bottom line is that we just are asking the court to follow the process we're supposed to follow. If there's evidence to be presented, let's present it as an evidentiary hearing. There is no immediate danger to these children. The two incidents that Ms. McKellum referred to, one, the minor child lost her cell phone, so she called dad, said she's not safe. The second one was an incident with the 18-year-old because he got his Xbox taken away from him. So this is the level of things that we're talking about that then escalate to the police being called and then running to dad's house, and dad's, welcome them with open arms instead of saying, no, you lost your Xbox, go back to your mom's. But the bottom line is the incident with that Ms. McCallum just brought up is this week, not what they filed their motion based on. And my understanding is with an 18-year-old. If the 18-year-old doesn't want to go to mom's house, I mean, this court's not going to force them. We're not going to force them. So it's bizarre that our whole basis now is on an 18-year-old when we're really talking about the 13-year-old child here. So the bottom line.
Do you have this incident report or anything from the?
I do have the incident report.
I'm asking Mr. Colvin because this is all new, something that he is not even, I don't know how much he's prepared to respond to.
I just got it last night for my client, Your Honor, so I did read through it briefly. And Ms. McCallum and I talked about it this morning as much as we could. I mean, if there's, I don't know. I mean, here's the thing. We have to show a change in circumstance or proper cause before we start appointing guardian ad litem, before we start, taking these extraordinary actions on a change in custody. I don't know. I think it seems like these children don't want to be disciplined and they found a manner not to do that by calling the police or dad.
Can I clarify one thing with the most recent incident? My client did have the minor children go back to mom's house when they came and showed up, when it was not his parenting time. He did do what was appropriate and send them back. The police had them go back to his house at the end of the night, and plaintiff had agreed to that. And in fact, I believe does not want her son to come back to the house at this point. I'm not sure where all of that stands, but there's some clear issues going on here, Your Honor, and we need somebody to.
There are some clear issues that are disputed, and I just, it's a Friday morning. I can't change custody on a Friday morning, nor
I'm not asking.
Do I intend to. I can't change schools on a Friday morning, nor do I intend to. I intend, and I can't send it to the friend of the court unless I find proper cause or change of circumstance, because by sending it to the friend of the court for that type of referral, it says that I have found proper cause or change of circumstances for them to investigate custody. I'm not saying that you're not right. I'm not saying you're wrong on whether there's proper cause or change of circumstance, but I've got to have a hearing, and I'm doing it as soon as I can. And I intend to get, I'll tell both of you, you better, you're only going to have an hour and a half, probably each of you, including everything, because I got to get to the bottom of this as soon as I can. All right. And I'm not going to let this just kind of start lingering so that we don't have a proper cause or change of circumstance finding in September, and then it goes till 1st of November, and then it's not going to happen. I'm also going to meet with you, both counsel, sometime in early September or sometime mid-September, whatever. We got to get through this. You got to exchange these things that need to be exchanged. We need to get an answer, at least on proper cause and change of circumstance, on the 27th, or we need to have all the evidence and let me make a decision on it based on that. So I'm warning you right now that if I have to limit each of you to an hour and a half, I'll limit each of you to an hour and a half. It's just got to get done. This is an important, I'm not saying anything good or bad about mom or dad. All right. I looked at that police report and I'm going, oh, geez, well, Pete, it does sound like dad's, I don't know, he's talking to the kid and mom's told him that she won't do her chores and that's why her phone's taken away. So he calls the police and the police go over there, and it seems like it was completely unwarranted because the police found exactly what the mom said and did not find that the child was in any danger. And that's one of them. Now, I don't know what happened this last Monday because I don't have anything about it other than the statements, but I'm telling you that's what that incident looked like, the one in earlier July. But that looks like dad's playing with the kids saying, okay, you don't have to, your mom's mean to you because you didn't do your chores. These parties need to figure that stuff out. But maybe it's unwarranted because of what happened on this last Monday. I don't know. But I guess what I'm saying is there's nothing that has changed other than to have this. I'm required to have the hearing. I'm going to have the hearing. It's as soon as I can get it is the 27th. We will meet with both counsel prior to that so that we can make that a smooth hearing. The two of you need to look at paring down or getting to the point right away. I don't want to dance around stuff and all this kind of what I consider garbage. And get to the point and let me make a decision whether there is, and if there is, then I'll consider appointing a guardian ad litem, because a guardian ad litem would probably give me more information in a quicker time than would a referral to the friend of the court for custody. All right, because if I refer it to the friend of the court, then holy smokes, it gets months till it comes back, and then I guarantee you one or the other is going to object to it, and then I'm going to set a hearing anyhow. So the
Your
bottom
Honor.
line is the two of you guys can even discuss prior to that hearing in case I do find that there is proper cause of change of circumstance who you'd accept as a guardian ad litem, because I think that would probably be appropriate at that time. And both counsel are shaking their head.
Your Honor, could I simply request one limitation on parenting time, that there be no alcohol consumed before or during parenting time while we're pending the evidentiary hearing?
Mr. Colvin, until that time, both parties will be restricted from any alcohol. Do you have a problem with that?
No, Your Honor, we would agree to that.
It'll be mutual. Nobody can, while 12 hours before or during any parenting time, there'll be no alcohol consumed by either party. And believe me, if it's proven that there is, I'm going to do something then right away. All right.
Understood, Your Honor.
All right. So that is, that can be in the order. Anything else?
No, Your Honor.
No, Your Honor.
Thank you both very much. Have a good day. We'll see you sometime before the 27th. You know what I'm trying to do, so you guys got to communicate, okay? You got to send your exhibits to each other. We don't need to have probably police officers come in and say, yes, that was my report, and read it to me, all right? That kind of stuff. Because police don't generally have a lot of information about cases like this. They'll just come in and read what they wrote, all right? Agreement on foundation, maybe on some of these things that just don't, if it's written by the Rockford Police Department, you know what I'm saying? You've both tried this stuff, so I'm going to cut through some of the lawyering stuff, all right?
Yes,
Good luck, everybody. Thank you. We're adjourned.
Thank you.
That was the last one. It was number 22.
Yeah.
1:70 PM, Dang versus Tit. We have Mr. Dang present asking for a motion. Sir, how did you get this motion to her?
I hand it to her. I hand the motion to her.
When?
The same day I filed the motion.
So more than a week ago?
Yeah, more than 2 weeks ago.
You handed it to her. Did she say anything?
Nope.
All right, she's not been present during this Zoom meeting at all. She's not here. According to Father, he's given her proper service. He's simply asking that the oldest child of the parties, he says, is now 18 and has graduated from high school, which would stop child support for that 18-year-old. Sir, please raise your right hand. Do you solemnly swear or affirm testimony given in this case to be the truth, whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. You stated that your oldest daughter has graduated from high school. When did she graduate, sir?
May 14.
What school did she graduate from?
East Forest High School.
I'm sorry?
Eastern Forest High School.
Okay. And clearly she's over 18 because she was born in 06, 1/1 of 06, correct?
Yes.
Does she still live at home or what?
She still lives with her, yes.
All right. But through his sworn testimony stating that the child has graduated and is 18, I believe in the child support order, it says post-majority support can continue until 5/31/25, which is probably why they continued it. We will issue an order that child support shall immediately stop as it relates only to that the oldest child, based on your sworn testimony here today. All right?
All right, thank you.
It'll take a little bit to get through, but we'll get it stopped, okay?
Okay.
Thank you. We're adjourned.
Thank you.
DP Mitchell v. Hall. Both parties are present via Zoom. We have motion filed by the father regarding parenting time. This has been renoticed from 2 weeks ago. And he has been found to be through the paternity case, to be the father of Harmony, who I believe is close to 1 year old.
Yes, she is.
And he is
She'll be
seeking
1 year
parenting
old
time.
on
He
Sunday.
is seeking parenting time. Now, it's kind of odd, Mr. Hall, because your objection to child support only a month or two ago, maybe 2 months ago, said you were homeless. And that's why you couldn't pay child support and all this kind of stuff. Do you have a home?
Yeah.
Ma'am, do you know, does he have a home?
I'm not well, honestly, because there's text messages stating that his mom's house has been his house, even
that's fine.
after stating the courts that he was homeless.
Well,
so I don't know if he's really homeless, if he's staying somewhere. I don't know nothing. As far as I know, he doesn't even have nothing for even Harmony to sleep in. Like you said in the court response, it says he can't even afford a place to go himself. He can't afford a car. He can't even, but it doesn't make sense because at the same time in the court response, it says I can afford her expenses. But I've had in text message that even after the DNA test was done in text message, I still can't help with Harmony. So he's refusing to help.
That's not what we're here about. We're here about possible
Right.
parenting time. If he has some place where he can parent the child, he gets a chance to see his child. Okay, you understand that,
I understand that. I just don't know if he does or not.
sir? Your response.
Yes, I'm paying rent at a place and then I'm trying to move out.
You're paying rent at a place. I mean, is it dégagé? I don't.
No, it's not a shelter.
Is it somebody's house? You have
Yes.
you have a room? Do you have what do you have there?
Yeah, Harmony have a room, yes.
Give me some information so I can feel, well, look at, maybe the best thing to do is to refer this to the friend of the court for parenting time. And they can do an investigation. They can find out where you live and if you got an appropriate place. So if you got an appropriate place and things like that, I'll see to it that you get some time with your child and in an appropriate amount.
Okay.
You're telling me you're, paying rent,
About
but
the expense thing. I don't know why she brought up my expenses. I'm not gonna hand my baby's mother money. I'm gonna give it to the state or the courts who ordered the child support. Well, she
that's
did,
right.
but
You pay the child support and
I don't have a problem
or
affording.
you pay the
Harmony.
child support. In the meantime, I'll refer this and waive the fees to the friend of the court for them to make a determination on what is appropriate parenting time. I am certain that if you can show to them that you have a place to live and even Miss
And a bed for Harmony. Sorry to interrupt you.
Miss Mitchell, you understand that if he has an appropriate place to take, he's going to start getting some parenting time and we'll probably get to a appropriate amount of parenting time.
I understand that,
right.
But I also need to let the courts know that I'm also not in Grand Rapids. So if he's willing to even meet halfway, if parenting time does get issued, he can meet me halfway once that gets figured out, and I'm fine with that. I just want to make sure my child is safe.
Where did you move to?
To Muskegon. It was a short move, a last notice move. I've been trying to get a hold of the courts to notify them of me moving from.
Make sure you notify the court and the friend of the court, because we got to get your address.
That's no
Because
problem.
have you told the friend of the court where you moved?
I've been trying to call them. My phone service, Metro, does not work well in Muskegon. So I'm going to let them know today through my boyfriend's phone number that I moved. I've been trying to. It's just been hard.
You need to you might have to drive over here and give the friend of the court your address, okay? Because they're going to send out something to you about parenting time. If you don't answer it and you don't participate in any way in this, they're going to make their decisions based on just what Mr. Hall says. Then you're going to object and I'm going to say you needed to participate, all right?
Yes, sir.
You're not going to be able to not participate and get away with this. All right.
Yes,
Same
sir,
to
I
you, Mr.
understand.
Hall, both of you. You need to make sure, Mr. Hall, I don't know what your address is, and I'm not going to read it all because we're on YouTube, but is it 5154?
Yeah, that's a mailing address. I can.
That's
give the
fine.
friend-
Make sure you
Yeah.
get information, the friend of the court so that we can come up with something appropriate, all right? In the meantime, ma'am, if you feel safe, you can always allow him to see the child some if you want. If you guys can figure something out, but certainly the friend of the court is, and if the friend of the court doesn't after they look at it, I will. He's not going to be kept from the child.
Oh, I don't have no problem with him seeing her. That's not the problem. I just wanted to make sure he was having her around safe people and she had her own things and everything because
Or
I don't believe
do you want to
he
have
has-
an hour, do you want to have an hour a week at some place like Journeys or something so that we know?
if
what you're
it's in
doing?
public and everything, I have no problem him seeing her as long as it's in a public setting. That's all I ask. And that's all I've been asking is that it's in a public setting. I have not kept him from this child. Nothing.
So no home visitations, not even supervised.
No,
I'm
she will
trying to
not be in his home. She has to have it in
We
public
will
place.
get to that. Sir, do you want, every, I don't know, Saturday from such and, from noon to 2 o'clock at Denny's and something or whatever?
Yeah, like alternating weeks, like every weekend I get.
He's not saying you get her every week. He's saying starting out would be Saturday from 12 to 2 in a public setting. You're not getting her for a full week or anything like that.
Don't want her for a full week.
Oh, well, I'm just saying.
All right, we're just gonna
it.
send it to the friend of the court. Please respond to him. We'll talk to you later. All right?
Okay.
Good luck. Thank you.
Thank you.
Are we gonna be anywhere near meeting the 11 o'clock?
Might be close.
All right. I know you're trying to get me through this. Well, the last one's supposed to not get on till 11, and we got 20 minutes to finish up a couple. Did you send her, Miss Jackson, a copy of this motion? You say you sent it to the Jim Williams Motel?
Yes, sir. I have the receipts and everything right here. I had it tracked and everything. She got it the next day.
What was the day she got it?
When did you do it?
6/21/24.
All right, and there's plenty of time. This is the plaintiff's motion for a DNA testing, but the kid is 16 years old. Was there ever a finding that, sir, your camera's gone. Was there ever a finding that you were the father? Mr. McClurkin, where did you go? Sir? Hello? Perfect. No, they're gone. It's the second time. 008 DP. It's a motion filed by the plaintiff in a paternity test for asking for a paternity test for a 16-year-old child. Have you, have you ever been found? Do you have a paternity order? Did you sign an AOP? You've not.
No, sir. I have nothing. What happened was when he was born, me and her weren't together. I picked her and him back up. She was living with her mother in Taylor down by Detroit.
Yeah.
And I brought him back, and and he's been with me the entire time since he was approximately 2 weeks to a month old. And I just never worried about it, never thought about it. And me and her would separate here and there over times. But we always get back together, but the kids would always stay with me. And this last time, it was to the point of where it was no good in the household for anybody. So I proceeded to give her an eviction notice because we were never married. And she left that week, went down to Taylor, Michigan, and that was it. She came back 3 months later. I tried to let him be in her life and everything else. And then it got to a point my son don't even want to go over there because all she did was take him and go party hopping every night and go drinking and take him with her. So now he's to the point of where he didn't want nothing to do with her. So then come just this past November, because he's got Medicaid, but I have no access to it because it's all under her. She's got all the government assistance, the food stamps, everything through him. So I've got nothing of him. And he
living with you still?
Yes, sir. He's with me right now. If you'd like to speak to him.
No, I don't need to. I thought so he is basically, and he's your son as far as you're concerned.
As far as I'm concerned, he is my kid.
Regardless.
I don't need a DNA test to tell me otherwise.
But
I
the
just
two of
want-
you- but the two of you were never married.
No, sir.
All right.
And we've been,
I mean, I'm only saying this is if I do a DNA test, you're sure it's going to come back that you're the father, but
no, I'm honestly, I'm not sure. But at this stage, the other guy don't even care because she was living with him at the time when she found out she was pregnant with him, and he kicked her out. He don't want nothing to do with. He's never tried in 16 years to even find out.
I mean, this is kind of a unusual case in that he's your son. I don't care what it comes back as.
Correct. He is mine. If that comes back 99.9, he's not mine. He is still mine. He's been with me for 16 years. I'm not going to turn my back now.
No, I
So-
give you. Yeah.
And she will not. And see, the whole reason why this got started like this was because in November I took him personally over to her so he could get his birth certificate and a social security card so he could get a job. And she said that she couldn't give it to him. She gave him a photocopy of his social security card, and that was it. And then I guess her boyfriend got in the middle of it and said, "Well, your mom might need that for something."
Yeah, to claim them.
And that was where that subject ended. And after that, my son was like, "Dad, I'm done. When can I get my stuff? When you going to court?" And at that point, it's been me dragging my feet. In all honesty, Your Honor, so where we're at now.
Well, it's because, quite honestly, I understand he's your son. No matter what, biology is the easiest part of raising a kid. All right, of having a child. The tough part is, where does your son go to school?
He goes to Godwin. He's been going to Godwin Heights ever since he was in first grade. He's been in the same school district the whole time.
All right. I might. All right, I'll order a DNA test, but it's gonna, even no matter what it comes back, we're gonna have a hearing on it. If it comes back that you are not the father, we're gonna have a hearing on it and determine whether, even if it does come back that it is not, whether the court still finds you to be the father. Because the court's gonna find you to be the father regardless of the DNA, all right?
Right,
okay. Look for an order. It'll be for you and him to get tested.
Okay.
We'll see what we can do on it, and I'll take it from there, all right?
Ask what he's gonna do to her.
All right, and then, like I say, even if it comes back you're not, we'll have an evidentiary hearing. I'm wondering if we should have one and not bother with DNA, but if you want to have a DNA,
I'm not worried about DNA, Your Honor. I figured I'm just trying to go through the proper channels of help.
I appreciate it. If I come up with some other answer, because I got so many cases this morning, if I can think of some other answer, I was thinking you were saying, hey, wait a minute, they're calling me the dad and I'm not, okay?
No, sir. No,
That's what it usually is, okay? Not this way. We're gonna make you the father at some way or another. All right. So I'll do DNA and watch. My clerk obviously has a way to contact you also. So if I can think of something else, we might just set up a hearing to determine whether you're father or not. All right.
Okay.
Good luck. Thank you. You'll hear from us.
Okay. Thank you.
Thank you. Have a good day.
Yep. You too. Bye-bye.
Just set up like an hour evidentiary hearing. He comes in and he's been the father for, because I think he's trying to say, well, yes, but I think it's because he can't get any benefits or anything for the child because he's not considered a legal father.
This one is just offended. Plaintiff was on, but has walked out. I haven't seen her walk back in a while.
Rodriguez versus Segura. The defendant, Mr. Segura, is on Zoom. She has logged in and logged out. My question is, this was a case filed by the prosecutor, correct?
I'm not sure, Your Honor.
You didn't file a case on this. You're just filing something on it. The prosecutors, did you notify the prosecutor of this? Because they're part of it.
Yeah.
You notified the prosecutor's office?
Yeah. Yes,
How?
Your Honor. I went to, I think it was the second floor, and I turned it in by mail. They said it was good to go.
So you didn't know that? Yeah, it's unfortunate, young man. You don't know kind of what you're doing. All right.
Well, I followed those steps of what they requested me to do in order to get this motion in set.
Yeah, but you have to notify the people on board. I've had a prosecutor here on a couple of other cases, and they have, I don't think they had any notice that this was up. This is their case, okay? This is their case that they filed, not you, but the prosecutor's office, I think. Yeah, they're the ones who filed this case. And can you, and I can't imagine they would have a problem with entering a paternity order, but like I say, it's their case, and if I go and enter something that they don't even know about, and they have the right to know, all right, they could object. They aren't going to, but it's unfortunate, but I don't see that you notified the prosecutor's office at all.
And in layman's terms, in that process, what was I missing?
Notification of the prosecutor.
And how would I do that? They never told me anything to.
They never. What do you mean they didn't? Who's they didn't?
17 Circuit Court. I went down there.
They don't give legal advice. They don't give they accept the stuff you give and they send it on, and they aren't there to tell you you got to do this, that, and the other thing. See, that's the problem. You're trying to do it all on your own and you don't know what you're doing. That's why you have attorneys. That's why you hire attorneys, because they do know what they're doing. I'm going to notify the prosecutor's office of this request for 2 weeks from now. I can't get it to them any faster. I'm going to notify him. All right.
Okay.
And I'm gonna send notice. Can we notify her? She's been on and now she's not. All right. So I assume she has some notification of it also. Now, I'm not going to read your full address, but is it 2213 is your address?
Correct, Your Honor.
All right. And to the best of your knowledge, she still lives at 847?
Speaking with the grandma, she does not, but she does claim to pick up her mail there. Grandma has spoke with me, and in the past a month, she has not lived there or has picked up her mail.
But she was on. I don't know how she'd know about it.
Text, email. That's how I got everything too.
You have emailed her or texted her?
Texted her.
All right. We're going to send notice to the last known address, which is her grandma's apparently. But you can also text her that, I don't want you reading her text because we're on YouTube. Okay. But, can you contact my clerk? Did you have a text for her or an email or anything? Can you, call my clerk and leave a message if she's not there, soon, and give her the information that you have to be able to contact her through text?
Yes.
Her name is Tracy Dewey, but her phone number here at work is 6104. You can contact her soon, even if she's in, and leave a voicemail with clear indication of how we can text her also. Okay.
Okay.
And then I'm going to notify the friend of the prosecutor. We'll have everybody back in 2 weeks and we're going to get something done on this. All right. I can't imagine the prosecutor's going to object to it, but I have to give them notice. That's how things go.
Okay. Yeah. I'm sorry, Your Honor. I've just been really frustrated.
You don't have to apologize, but the best thing you probably could have done was get some legal help, but end of story. I'm going to do something here to try and see if we can get this done.
Okay,
all right.
Please. Thank you, Your Honor.
Thank you. Honor. We'll see you in 2 weeks.
Okay. It's hard.
Thank you.
Thank you.
See, last time I think he was here, he wasn't legal father and he wanted parenting time. I couldn't believe it. 0-DS, matter of Vasquez versus Reyes. Ma'am, how'd you get Mr. Reyes notice of this motion today?
I actually went to go take it to him the same day I took it to the court.
You took it to him?
Yeah.
You handed it to him?
Yeah, I have a video and a thing. So I have a video that he received it.
All right, and that would have been on like July 12th?
Yes.
All right, so you know he has, you know he has this.
Yes. He received it because he had gave me a phone call telling me what I was doing, and I told him, I'm like, I want my full custody because you're not gonna keep on putting your hands on her.
All right. The we have the plaintiff here who has asked for custody of the child. Ma'am, you understand that you have a custody order right now.
Yeah,
I mean,
they were telling
you're just poking the bear because the only order in this case gives you custody. Now, it's without prejudice that either party can file for it, but you have custody right now. That's what the order says.
Okay.
It says mother has initial custody of the child without prejudice to the determination of either parent's custodial rights. If he were to file and say, I want a custody hearing, I'd have to have it. All right. But he hasn't. You have custody right now. And the only parenting time is as previously ordered. And there isn't any previously ordered. All right. If he wants parenting time, I guess he'd have to file with the court if you're not going to give him any. I don't care. We can have a custody hearing. The only thing you can get is custody, which you have the initial custody, and he hasn't done anything to change that. He hasn't asked for it. So I'm not sure why you're asking for custody when you have it.
I wasn't sure if I had the full custody or not because when he had came over here and took her, the police said that they couldn't do nothing about it because it's not a court order saying that my daughter was physically my full custody at the time. So I was
How did they know that?
I don't know. They had asked me and I told them like I don't have any proof that I have full custody. But
See,
she
that was
stated,
your problem because the order that came out in June 17, 2021 says it is ordered. The mother has initial custody of the child.
oh, okay.
Maybe you should come down to the court and get a copy of that and keep it with you.
Okay, yeah, because I didn't know that.
I mean, I can have a custody hearing and all that will result in, I mean, I know you have initial custody, which says basically temporary custody, but there's been nothing to change that. He hasn't tried to change it. The only order of custody is for you.
Okay.
All right.
Well, I wanted that, and then I don't know if it's possible to change her government last name.
No, that's not going to happen through me.
Okay. Thank you, though.
All right. Good luck. Thank you. Come down and get a copy of this order so that it says mother has initial custody. There's no other order. All right.
I will.
All right. Thank you. We're adjourned. Thank you. Can you hear me, ma'am?
Yes, I can hear you. Can you hear me?
Not for the child. She's to leave.
Okay.
How did you get him this motion?
I mailed it to him.
When?
I mailed it to him on the 5th of this month.
Yeah, and is that return receipt or something like that?
This is the receipt that the post office gave me whenever I sent it.
All right.
And you can see the date there. It's sealed.
I didn't see the date. Was it ever?
It's on there. It's in the seal from the U.S. Postal Service from July.
I know what that is. I don't know what that. Apparently, she mailed it to him. Do you know if he ever got it?
I have no idea.
Address or anything?
I don't talk to him, so I don't know.
Well, is that the last address you knew that he was living at?
Yes.
Okay, and that's I'm not going to read it, but that's the 520 address?
Yes, correct.
All right, this is apparently proper service. This is a motion by the defendant. This is a request from the mother for custody. You make many allegations about the father, is isolated, the child uses drugs, neglects dental and eye care. He says he's arrested in Florida in 2023 for drugs. I don't have anything about that. You even admit you don't have anything. Talks about having to clean dad's room and, and whatnot. However, this child has for basically her whole life lived with her father. Isn't that correct?
Since she was 3.5, 4,
Yeah,
she's lived with him.
You have been, I think you kind of say you weren't the best. You have been like living all over the place and in frequent times just not even involved. And now,
No, sorry,
what?
go ahead.
And now,
No, so her entire life, her father has kept her from me. The only reason he had her was because I moved. And when I moved, our agreement was that he was going to stay with her temporarily. When I moved, he kidnapped her. We both lived in Florida at the time, but he kidnapped her, and I tried getting the police involved. They wouldn't help me though, because in the state of Florida, the father has rights to the child just as much as the mother does. And he moved to Michigan, and that's when he filed the whole paternity case over there.
yeah. And he got custody and everything here.
Right, because I didn't know that the court date existed.
Well, when did you, he got custody a long time ago.
Right, he has.
And you didn't know anything about it for how many years? Come on.
No. I found out about it right after it happened, and I have been involved in her life. I do talk to her on the phone. She's here with me now, but throughout her life, we have been in communication. We did speak, but the thing was that her father would keep her from me. He would, every time I would call, he'd say, "Oh, I'm busy. She doesn't want to talk to you." It was always.
For how many years has that gone on? I mean, the court's been here forever, and I mean, at some point, shame on him for keeping him, but it becomes shame on you for not taking any affirmative steps after a while. Okay. And it's true. You didn't take much in the way of affirmative steps to do anything. And now you're asking for custody. And so how long has she been with you?
Since May.
And I know I believe there were a lot of allegations that he was domestically abusive to you.
Yeah, no, I had a restraining order on him whenever she was first born. It was for a year.
Well, I understand, but I mean, do you live in the state of Michigan now?
No. I tried to have the case domesticated over here to North Carolina where I live at. And unfortunately, they said that in order to have it domesticated, I have to physically be there in person in Michigan to file. So I tried talking to the legal assistance department over there, and they said they can't help me because I don't live in Michigan.
So you're saying North Carolina needs you to be here to have it domesticated in North Carolina?
No, I tried to have the case domesticated from Michigan to North Carolina where I currently live. And the state of Michigan told me in order to file to have this case domesticated and move from Michigan to the state that I live, I have to do it in person. There's no way for me to do it on the Michigan's website.
The problem is going to be, even if I say I can't change custody on a Friday morning. I can't. I have to have an evidentiary hearing. And I'd have to have an evidentiary hearing here. Both of you are coming from North Carolina and Florida to have an evidentiary hearing here or whatever. Even apparently all the evidence isn't even in Michigan, is it?
No, it's in Florida because that's where we originally lived before he even moved to Michigan and filed the case originally.
I mean, because what you're forcing me to do is say, yes, and she's lived with you that long. There's probably a proper cause or change of circumstance to have a custody hearing, and I can set up a custody hearing. It'll be a few months from now. But we can set that up, and then that's all I can do. I can't change custody today.
The problem is that she's supposed to go back to her dad on the 31st, and he is a violent person to her. He has hit her. He's punched her through the shower curtain. I mean, she really wanted me to make sure I did this case while she was here because she wanted to make sure she could speak to you on her own. And make it very.
That's not allowed.
Yeah, I know. But there are witnesses to the abuse that's happening. And the problem is that she's speaking up against her dad, and her being sent back to her dad is not going to be in the best interest for her. Honestly,
she's enrolled in school in Florida?
She was enrolled in school in Florida. I don't know if she still is or not.
Well, I assume she was wherever she went to school last year, she's still there.
More than likely, yeah. And I do worry now that she's spoken up against him because there is an open DCF case over there in Florida right now. I do worry now that she's spoken up against him. Sorry?
For what is the CPS case?
The CPS case was in April. He's been neglecting her. He was abusing her. He hit her. I called CPS and got CPS involved because she said that she was to a point where if she had to stay with her dad, that she didn't want to basically be alive anymore. So I got CPS involved with the case, and they came out to the home and they saw her. They came out to the school. The police came out and saw her and everything. And then since she's been here, CPS has come and saw her here.
Okay, and what has CPS done? I mean, have they issued a report saying we find neglect on the part of the father or abuse or anything?
It's still open.
Okay, but their investigations are...
They're ongoing still.
I don't know if you realize the position that I'm in, okay?
I do.
I don't have information that's documented. If I had a CPS report that said, we find that, you know, something is inappropriate with dad, that works out great. What does a court order say as far as returning her to her father?
There's not a court order as far as returning to her to the father. He did have me sign a paper stating that I agreed that I would send her back on the 31st. So I do have a notarized document stating I'm supposed to send her back on the 31st, but I worry about doing that for her because of her safety.
Wish you hadn't waited so long. Can, is CPS indicated that they will have some kind of report done in the next couple of weeks?
I can contact them and find out. I haven't heard from them in a few weeks since they came out and visited her.
And they came out and visited because of the ongoing investigation in Florida?
Yes, yeah. They needed to know where she was, so the police came out and they did a wellness check on her.
And you have nothing from CPS in Florida stating that they substantiated against him or anything like that?
They haven't sent me anything, no.
You have people to contact down there so you can get some kind of...
I do.
I need...
The caseworker's name is Stephanie.
Well, I'm not going to call her. That's not my job.
Do you need me to call her?
I need something from CPS.
Okay.
And I need something indicating that she's at a risk of harm or something like that.
Okay.
All right.
What
I'm going to do is, on a temporary basis, the court is going to issue an order that gives you extended parenting time through through August 24.
Okay.
All right. Extended PT through August 24. To enable the defendant to provide information from CPS. And then I'm just trying to see what our motions are on this time. So we got this is the 26th, the 9th, the 23rd. And I'm going to reschedule this motion for the 23rd. All right.
23rd of August at
Yeah.
same time?
Yes, it's, you know, I get a whole bunch of them. So unfortunately you have to wait and things like that. All right.
Yeah, it's fine. I understand.
And we'll revisit the issue at that time.
Okay.
So I'm giving you 4 weeks and you better get me something that's substantial.
Oh no, I'm gonna get on the phone.
If it says we find no problems down here, I can't just, I can't prevent it.
Right.
I got to have an evidentiary hearing.
Okay.
All right. So.
So it's going to be for August 23rd, and I'll get on the phone with her as soon as we're done
August
here.
23rd motion. And you better provide me something other than you saying this stuff. I'm not accusing you of lying and that kind of stuff. But you understand, I got everybody on here today and says bad stuff about the other person and all that stuff. All right. You got to provide me something from a third party. Somebody who I can trust. Counselors, doctors,
Okay, I can
CPS.
do that too because she did have a counselor. He was unwilling to let her speak to them. He was basically monitoring everything, listening to them. It was never.
I read your
Yeah.
motion and all
Yeah,
that
I know it was a
stuff,
lot.
but you got to get me something that gives me a feeling that I should do this, and then we got to also work on. I'll look into domesticating your judgment.
Yeah, because I mean, I don't feel that it should be through Michigan.
How long have you
I've
lived
tried
in?
to.
How long have you lived in North Carolina?
3 years.
All right.
Yeah, I've lived
All
over here for 3 years. So, something from the CPS officer or counselor.
Well, you gotta give me something that convinces me I should leave her there at least until a custody hearing.
What about like a witness that's witnessed the abuse?
I can't give you what to
Right.
do. Okay.
Right. Well,
I can't tell
I
you.
have the witness, her stepmom, actually, the one that he was with when he originally filed the motion.
Yeah, is the
who has-
stepmom with him still?
No, they're not together. She left him because of the
you
abuse.
understand that I get ex-wives, ex-husbands,
Yeah.
ex-girlfriends, always say bad stuff. Most of the
Right.
time, I don't take much of it into consideration.
Right. No, I understand.
So,
I do. I understand that
Get
full-heartedly.
somebody and just bring a motion. I'm telling you, I need something more. I'm giving you her until the 24th.
Okay.
And we're having a hearing on the 23rd. Give me something that would make me want to say, okay, we'll extend that for a certain amount of time until we have a custody hearing.
Okay.
Actually, yeah. All right. Good luck. Thank you.
Okay. Thank you.
Richard. Last one. Not bad. Wrong file up to me and hand it back and call a case that isn't even in front of me and all that kind of stuff. It worked out wonderful. Just having a discussion with my clerk here. As to how much longer she's gonna work here. Plaintiff, formerly Miss Haddad, is present with her attorney, Mr. McConnell. We have Mr. Haddad represented by Miss Ross. There are a couple motions filed in this case. It started out with a motion from the plaintiff through Mr. McConnell for modification of parenting time. There's also been and I've read that, I've read the response. There's also been a motion filed for appointment of a guardian ad litem for the children, and that was filed by defendant's attorney, Ms. Ross. So I've read the motions, I've read responses, whatnot. The long and short of it appears to be that the parties agree that the court needs to set some kind of specific parenting time. But I'm going to let you start out, Mr. McConnell, and have a brief statement if you'd like.
Yeah, thank you, Your Honor. I would kind of, I know the court reads all the filings and the court's not interested in attorneys regurgitating what they've already written and filed. I just want to focus on the response.
Yeah, please don't do that.
The response is kind of, it makes the point that we're trying to make in terms of our motion, which is we believe that the defendant needs some boundaries. We think that the evidence we provided can show the court that this defendant is simply trying to exert a certain inappropriate level of control over the plaintiff's household, her separate household, and how she's going to co-parent these kids. We don't think he's interested in co-parenting. We think the evidence shows the court that he's interested in solo parenting, parenting how he thinks it should work. And so our motion is about just modifying the current parenting time order to set some boundaries and to kind of limit the efforts of the defendant, which again, we think we provide the court with evidence that there's evidence here that this defendant needs some boundaries. And that's what our 6 specific asks are for in terms of modification of the current parenting time order. We're not looking to change a whole lot. We're just looking to set some boundaries. And I think if the court wants me to go through the 6, I can go through the 6.
No, let me just start out with this in some kind of a reasonable manner here, okay? The first thing basically that you've asked for, and that I think Ms. Ross even would agree to, is that there needs to be a change to the parenting time language to set specific parenting time. Now, the court does not, I mean, if parties agree, no matter what they put in a judgment of divorce, that they think that they can live with in parenting time, I certainly wouldn't mess with it. However, this parenting time order is, I think I don't know what you characterized it at, but it was characterized as convoluted or something. And from my perspective, that's probably a good characterization of it. And I think, Ms. Ross, you even agree that we need to do something to have some certainty with parenting time. I mean, there's parenting time provisions where she gets the children in the summer, but he can show up and be there for part of it. And I don't even know how long or what, but the mother still, if it's a mother's time, then she still dictates. But I mean, those kind of things. Isn't that long and short of the first part of your motion, Mr. McConnell?
Yeah, there's a shared parenting time provision. We want to get rid of the shared parenting time provision. We don't think that.
And we need to set, and that's what I intend to do, because it's not a workable solution to parenting time, I do not believe. Ms. Ross, do you stated in here, even in your response, defendant agrees the current parenting time should be modified to prevent further parent alienation and to correct current parenting time inequities caused by the ambiguity and plaintiff failure to act. That's the only way. I mean, I'm not saying you're right in half the stuff you said there, but we do need to modify parenting time and have certainty.
Yes, Referee Fredericks. I would agree to that, but what we do dispute is the reasons why the original agreement that Ms. Blair agreed to is not working, is not the fault.
Doesn't matter what the reason is.
I agree. I agree it doesn't matter. But Mr. McConnell thought it did when I spoke to him before. So I just wanted to make clear that he disputes the reasons why it's not working, disputes what she's saying. And yes, it does need to be reworked, but I would disagree with Mr. McConnell's claim that they're not asking for to change a whole lot when their proposal would reduce his shared parenting time with the boys by 30.22%. He is a long distance parent. Yep. So in the public policy favors giving as much frequent and literal parenting time as possible to foster and encouraging a relationship with the father. And by her requesting all of the spring breaks as the change and reducing what would be his shared parenting time under the original agreement, it's taking away the intent of the original agreement.
What do you mean reducing his shared parenting time? Like
if they eliminate the shared parenting time, he's losing what they intended he would receive by 30%.
I have no idea what
the bottom line is we're going to start out with a settlement conference between Mr. McConnell and you, where you're both going to send in what you think is appropriate for parenting time. The bottom line is also that Mr. Headhead is a long distance parent and he cannot have every other weekend and that kind of stuff. All right. There is summer, there is the winter break, there is a spring break. There may be, I don't know, there may be a long weekend sometime in January or February and this kind of stuff. That's basically what we're playing with, because he's not going to just get every other weekend and stuff like that. That's just not possible. And it also is not going to interfere with the school, with what the kids are doing at school. And he's not going to get all of the time that I just mentioned, because she gets a chance to have some weeks to have parenting time in the summer too. She's not just going to be the school mother, okay? And that he gets all the fun time. So we're going to deal with that, and both of you are going to send something in to me with your proposals. My clerk is going to get to you. We're going to set up a settlement conference within a couple weeks. I assume that would work for both of you. We'll talk about it. If we can't come up with a solution, we'll have an evidentiary hearing on it. That'll be fine. All right. There's no huge rush, because the major time that he is going to get is going to be the summer, and it's going to be a question of how much. All right.
Your Honor, I totally agree with that. I will get this settlement conference calendared with your clerk. I just want to be clear that as part of the specific schedule, we're also going to be proposing certain parenting time. I don't want to call them restrictions, but maybe just things that we'll all have to live by as we try to co-parent. That's going to be part of our settlement proposal.
I'm also going to tell you, I'm going to deal with the times probably separate from this, from what you are requesting, because number one, I want both parties to understand I'm not going to micromanage every minute that these kids are with the other side. All right. You got to understand that there are certain things that are just reasonable that are out there, and I'm not going to micromanage this. All right. But we'll get into that in a minute. All right. Do you understand that, Ms. Ross, what I'm expecting?
Yes. Should I respond to Mr. McConnell's statements, or?
Well, first respond to mine. Do you have any problem with what I'm suggesting? And I hate to tell you, but it doesn't matter, because that's what I'm going to do, but I'll give you an opportunity to put something on.
No, we have no problem. In fact, I had suggested this to Mr. McConnell yesterday, that we just agreed to proceed with either mediation or agreeing to the proper cause being there and then working on a proposed new agreement. So I completely agree with that, but
And don't let me, and I don't mean to interrupt, but quite frankly, if you guys want to do mediation, I'm not going to stand in the way of it. All right. If you guys agree on a mediator, but I'm not sure that you can even agree on a mediator. And so I'm going to set something up for some kind of a settlement conference. We'll probably have it in a couple of weeks, right? Give you enough time so you can each talk to your clients and draft something. I would like something drafted. I'm not going to make you come over here, Miss Ross. We'll do it via Zoom.
I am in Grand Rapids, but Zoom is fine as well. I'm work remotely. I am with the firm, but
all right.
I'm
well,
handling
maybe
cases
maybe
here.
it'll work out best if you guys both showed up here. I like it when both do, but I had your address in Troy, so I certainly wasn't going to make you drive here from Troy for it. But if you're local,
are we setting a date and time right now, Your Honor?
I don't. Can we do one?
I've got a couple of things coming up in the summer. I don't want to have a date set that I have to later have to try and get rescheduled if we can do it now.
I'm pretty busy
You got
too.
vacation, you mean? You're not going to reschedule your vacation so you can meet with me for an hour?
Only if you order me to.
Well, I'm not going to. Do we?
August 15th at 9 o'clock.
I have a settlement conference there or via Zoom with Judge Ackert at 9:30.
I doubt we'll be done in a half an hour. We can start at 8:30, but
August 20th at 10:30.
What was that? I'm sorry.
August 20th, 10:30. Ms. Ross, you got to chime in here too. I don't want to mess up.
August 20th?
Yeah.
I've got a deposition scheduled. I can't.
Oh, for Pete's sakes. Yeah, now you're the.
What date works for you?
Well, what?
August 27th.
Jesus, that's out a month from now. August 27?
That works for me.
I'm available the 27th.
Rachel, are you available?
In the afternoon? This is a conference between us. They can be here in the courtroom, but you're going to come into the back room and meet with me.
Yeah, do you want the parties there?
Up to you. I don't want to have Mr. Headed have to fly here from Washington.
Oh, of course not. Yeah, but
okay.
Whatever.
So, I mean, I'm going to tell you quite frankly, we're going to meet in the back room. I'm going to give you my thoughts and you're going to give me your thoughts and you're going to go talk to your clients. If we reach an agreement, it would be nice to put it on the record, but again, I'm not going to have Mr. Headed fly here for a settlement conference for an hour. He might be available via Zoom if he wants, or even just be available to Miss Ross for him to be called and we can determine, if there's a settlement to put on the record. She can call him, they agree to it, we'll go on Zoom and we'll put it on the record so that he can be there.
What time is again the 27th?
2 o'clock.
2 o'clock.
Okay, works for me.
Let me just make sure that. All right.
Oh.
No, we'll be done by 4 at the latest. Nope, that's all right. I have an important conference at potentially at 5. All right. So, and I would like, I don't have to have it way in advance, but I'd like you guys to exchange this document as far as what you think is appropriate for parenting time, at least a week in advance, so that you guys can talk to your clients about it and stuff like that. Okay. And again, if you guys would rather go to mediation, you can do that, but I'm not going too far with that. All right. Now you've been asking for a ton of other stuff. Let me also, maybe before we go too far, Ms. Ross has asked for a GAL, you oppose it, all right? Ms. Ross, you may briefly talk about that if you want.
Yes, Your Honor. It has come to Mr. Haddad's attention that the children are struggling with certain boundaries that are being violated by Miss Blair's current boyfriend. They're expressing distrust.
Like what boundaries are you talking about?
Specifically, the way he refers to them as certain pet names and like affectionate names.
Do you understand that I find that to be an absolutely absurd request on his part? Absolutely beyond absurd.
Because the children don't feel comfortable around her boyfriend. That's absurd.
It's absurd that if her boyfriend says, "Hey pal, come on over here," that he has to, I'm not going to order him to to refer to him as a specific name. In fact, I was so appalled by this, I ran by a couple other referees to hear it. That's an absurd request. That he can't, I mean, I'll tell you, he can't refer to him as a MF. I'd like to be able to say it, but if that's his pet name for it, I'll stop that, and that kind of stuff. But he probably calls him Wes sometimes, and at other times, hey, bud, come here. That is trying to micromanage this, and that is an absurd request. Go ahead.
Okay, well, the request is for guardian ad litem, so the child could speak their feelings without a fear of the parents or having to
What feelings do they need to speak? We're just dealing with the parenting time, which is basically kind of set. I'm not going to make a huge amount. It's not going to affect an established custodial environment, but I mean, we've all agreed there's only so many times that he can have the children. All right. And his time is limited by summer, spring, winter, maybe Thanksgiving. And that's what we're dealing with.
This is coupled with other discomfort by the children, which includes them being forced to go to his house when they don't want to. And there's a familial intimacy that's being imposed on them that they don't want. Just because he wants to have this really chummy relationship with them does not mean the children want that, and they shouldn't be forced into it by this third party or by their mother.
My feeling is that your client's filling the kids full of that. All right.
Well, we object to that.
Your request in here that says he's not to drive the kids anywhere. That was one of them. She must drive him, or family relatives and things like that. That's an absurd request. He's an adult. Does he have has he got a drunk driving that he doesn't have a license? Things like that.
He does have a history of driving without a license.
Family. You're not going to restrict I don't know if I'm calling him a stepdad. He's not really a stepdad and this kind of stuff, but you're not going to run the kids' lives at her house as she is not going to run the kids' lives at his house. He is not going to demand that the kids have pictures of him put up in the house. All right. That's another absurd request. If he wants it, fine. If he doesn't, but he's not going to micromanage her life there. She has another individual. I know he wishes that individual wasn't there. There's nothing that you have pointed out to me that he is somehow a bad individual. I don't know. And I guess I'm kind of asking, but if they're going to end up together and stuff like this, those sort of things are absurd requests.
Okay, just for the record, referee, what were the other referees that you ran the issue by?
None of your business. I'm just, we talk about motions sometimes, and I'm going, what do you think of this? I mean, I don't need that. I'm not making a decision based on what I ran by another referee. I'm making a decision that I think that's an absurd request. All right. And if any alienation, I'm starting to worry about alienation because he's telling the kids, hey, you don't have to go to that guy's house. She's moved on. Okay.
He does not care about her relationship. He cares about the best interests of the children, like he always has.
That's right.
That's what the evidence will show.
Are with her a majority of the time. And as long as she's not doing anything appropriate, and I haven't heard anything that she's doing inappropriate. I haven't heard anything that she is doing inappropriate. If she marries this man, what do you want? Kids can't be around him. He can't call him pal. He can't drive them. They're absurd. You can appeal this, and I'd welcome you to do that because it'll go nowhere. All right. This kind of micromanaging, this kind of the kids being used that, oh my God, your mother doesn't have a picture of you in the room with me. I'm going to say that to your mom. And he said in there that she can't let him drive the kids anywhere. This might be a life partner. I don't know if it is or not, but it seems like it. And you have pointed out nothing that's bad with him, nothing that he's even done bad.
Well, when there's an evidentiary hearing on the parenting time, that will all come out.
It will not come out about alienation. This isn't going to be about alienation because Mr. McConnell, I'm going to stop him because he has a better claim of alienation from what you have filed.
Your Honor, what evidence have you taken in terms of testimony? Yeah,
I haven't.
Exactly. So how would you know whether there's been alienation?
Your statements that you put in here, that the kids are being, he may call them a pet name that he is not willing to, I marked it in here. All right. let me see. Kyle is to address the boys by their birth names, birth given names, Blair and Wesley or Wes. He is not to call them by any other name, such as Buddy, or any name that would convey a closer relationship than I permit them to have with the minors, than he permits. That is not part of this. That's your statements that I'm dealing with. I don't need to have an evidentiary hearing unless you're putting stuff in here that doesn't belong in here.
Mr. Haddad will present evidence regarding the factors related to the best interests of the children in terms of Miss Blair's inability to put the children's feelings, needs, and comfort above.
This is not a custody hearing. This is not custody. You understand that, don't you?
I know the standard, Referee Fredericks.
This is not a custody hearing. If we cannot set an appropriate parenting time, which is like on, June 3rd till August 4th, he gets them at Sunday till whatever. That's the stuff that we're doing as far as parenting time. All right. If you think that you're going to try and change custody with that, you're wrong. Because there's nothing been presented and there's nothing that even comes close to Vidvarka. Go ahead. Anything else? You can make the record. That's why I put you guys on last. I knew that this would happen, and you can make a record for some things.
Your Honor, Referee, it's clear that you've made your decision on this.
I made my decision as far as this is a parenting time thing.
Okay.
And that's what we're dealing with. Anything else you want to put on?
No, we'll save it for the evidentiary hearing, Your Honor.
Well, you realize I'm not scheduling an evidentiary hearing on parenting time unless and until we don't reach something through a settlement contract.
I understand that.
All right. Mr. McConnell, anything you'd like to add?
I just would respectfully request the court to deny the motion for the guardian ad litem to be appointed. We can think of nothing more having long-term impacts on these two boys than having a guardian ad litem when we have no record of abuse or neglect before the court. We just don't think it's healthy to have these boys go through that.
I'm going to not appoint a guardian ad litem at this time, although depending on how our settlement conference stuff and goes like that, I will, maybe it's best to defer. Okay, if it becomes apparent that we need some guardian ad litem, but I'm certainly not going to appoint one now, not for parenting time at least.
Thank you, Your Honor.
Anything else, Mr. McConnell?
No, Your Honor.
Anything else, Ms. Ross?
No, thank you.
We'll see you on the 27th.
Everybody have a good weekend. Thank you.
Thank you. You too.